Good morning, ladies and gentlemen. I'm going to call the meeting of the Prisoner Review Board en banc session to order. I have a motion to open the meeting by Mr. Coates and seconded by Ms. Tyson. Amy, will you please call the roll?
Mr. Boland? Mr. Boland?
Jared Boland, appointed out of Macon County, present.
Mr. Coates?
Good morning, Matt Coates, appointed out of McLean County, present.
Ms. Globoker?
Julie Globoker out of Cook County, present.
Mr. Grubbs?
Jeff Grubbs, Jackson County.
Mr. Heaton?
Roger Heaton, Cook County.
Ms. Schaffner?
Good morning, Robin Schaffner, Cook County.
Ms. Taronis?
Good morning, everyone. Carmen Taronis, Cook County.
Ms. Tyson?
Good morning, Crystal Tyson, Saline County.
Mr. Tupy?
Ken Tupy, Sangamon County, present. Hearing 9 board members present, none missing, I'm here going to call the meeting to order. Do I have a motion to approve the board minutes of January 29th only?
So moved.
Any second?
Second.
All right, motion been made and seconded to approve the January minutes. Those in favor respond by voting aye.
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 All right, would you please call the first case?
Rafael Guerrero, presented by Ms. Tyson.
Ms. Tyson, you want to make your presentation?
Yes, sir. On April the 15th of this year, Mr. Rafael Guerrero was interviewed at Lawrence Correctional Center via WebEx. His interview lasted approximately an hour and a half, and he's represented by Sherry Davis, attorney at law, who was present for the interview. Also present were several of his family members, being Bianca Guerrero, Jeremy Guerrero, Evelyn Guerrero, Danielle Guerrero, Denise Guerrero, Juanita Guerrero, Nikita Thomas, Monica Castelos, and Javier Guerrero. Mr. Guerrero is a 37-year-old male who has been in Lawrenceville Correctional Center since October 23rd of 2024. Previously, he was at Menard, Statesville, and Pinckneyville. His MSR date is October 11th, 2032. He was 17 years old at the time of the offense. During the interview, he was polite and he communicated clearly. He cried when speaking of being sexually abused, his childhood, and the death of Miguel Diaz. A statement of the facts is that on April the 2nd, 2005, 17-year-old Rafael Guerrero was standing outside with another Latin King member when the victim walked past. Mr. Guerrero shot the victim in the chest and continued to shoot as the victim ran. Mr. Guerrero had been a Latin King street gang member since age 11. His statement as to the offense is that he was riding around in a van with other individuals at the time of the shooting and is innocent of the murder. In his petition, he explains that he was in the police station for 3 days and they tried to force him to tell who committed the crime. He said the police told him they would get his friend, Ramon to say he did it. Mr. Guerrero explained, and the appellate court noted that some of the people who signed statements against him renounced those statements. Those who renounced said the statements were made after they were locked in a room for days, not given food and water, and not allowed to see an attorney. Mr. Guerrero stated, and the state's attorney letter that's dated May 25th of this year acknowledges that 2 who made statements, filed and settled a civil lawsuit against the Chicago Police Department alleging improper police conduct during their stay at the police station. They received a monetary settlement before the trial began. Mr. Guerrero believes that this improper police conduct led to the statements implicating him. The jury, however, found that he personally discharged a firearm, causing Miguel Diaz's death. Mr. Guerrero was sentenced in Cook County for the criminal offense of first-degree murder. He was sentenced to imprisonment of 53 years, which included a 25-year enhancement for personally discharging the firearm. After the decision in Miller versus Alabama, his sentence was vacated and the case was remanded for a new sentencing hearing. He was then resentenced to 28 years at 100% on April 1st, 2022. At the time of the offense, he was living with his mother, sister, and niece. He was not working and he was not in school. He said that he was basically running the streets and was a member of the gang. He is now 37, will be 45 years old at the time of his anticipated release. He believes he will be released without the skills to support himself due to the amount of time it takes to be allowed to be enrolled in GED classes and the limited courses that are offered by IDOC. He desires to learn a trade. He realizes it is likely that if he stays in prison until he's 45 years old, family members will have passed and he will not have the skills to support himself. One day, he hopes to own his own barbershop and he wants to get a CDO. Mr. Guerrero seeks release to be able to prove his innocence and become a useful citizen. He hopes he will find new evidence from neighbors who lived in the neighborhood. He looks forward to building solid relationships with family members. He wants to start a business and give back to his community. He wants to help troubled youth so they won't be influenced by the wrong people. He wants to help the homeless and rescued animals. He hopes to marry and have a family. He wants to travel and join a church. He believes he's been a model individual in custody. While incarcerated, he did receive a certificate from Clothing the Homeless Winter Project in acknowledgement of a donation of $200 to help with clothing for the homeless shelter. His criminal history is that he was arrested numerous times, but he was convicted on December 4th, 2006 of an attempt battery bodily harm in Cook County and received 30 days in jail. And any juvenile record will be discussed in closed session. Mr. Guerrero was raised in a community where gangs, drugs, and violence are common. He did not know his father, and his mother had relationships with different men. When he was 9 or 10, he was sexually abused by his mother's boyfriend. He sold drugs in order to buy food and clothes. His mother was addicted to illicit drugs, and at one point DCFS put him in foster care system at the age of 11 for a few weeks until a family member took custody. He lost family members to violence and to alcohol. He was harassed, bullied, and physically assaulted at school and on the street. Some of his cousins were gang members, and he joined the gang, he says, at either age 11 or 12. He witnessed his cousins die because of gang violence. Also, his grandmother died when he was young, and both of these deaths had a negative impact on him. He has not been able to attend many classes due to the policy of the Illinois Department of Corrections. However, he does have certificates showing completion of 11 classes, including rehabilitation by regeneration and ACCI life skills classes. While at Menard, he worked in the kitchen and as a sanitation worker. He requested a work assignment at Lawrenceville and hopes to be eligible soon. Interestingly, Mr. Guerrero could not read or write when he entered prison. His cellmate read his mail to him until he decided to teach himself to read and write. He is now proficient at both, and he is in school now taking adult basic education classes and working to try to qualify to take the GED. He realizes that he has to have a GED in order to become a barber. He received tickets on 8 dates over 14 years between April 2010 and July 2024. 7 of the 8 tickets are major tickets, 1 being a minor ticket. In 2014, he received a ticket for gang or unauthorized organizational activity. In 2015, he received a ticket for gang or unauthorized organizational activity and fighting. In July 2024, Mr. Guerrero received a ticket for security threat group or unauthorized organization and gang or unauthorized organization activity, specifically, quote, establish STG group at Pinckneyville Correctional Center, unquote. Overall, Mr. Guerrero has been placed in segregation 6 times, once for a year. Other major tickets that he has include rule violations, disobeying direct orders, unauthorized movement, unauthorized property, insolence, sexual misconduct, and impairment of surveillance. When he's released, Mr. Guerrero will live in Berwyn, Illinois with his cousin, Danielle Guerrero, her longtime boyfriend, and her 3 children who are 11, 7, and 5. They are all in good health. Danielle's boyfriend has been a forklift operator for 8 years, and she's a housekeeper. When he is released, they plan to set up a bedroom for him in the basement and then remodel the living area, update a bathroom, and install a kitchenette in the basement area. He says that he can work with his sister's boyfriend doing painting, sanding, and construction. His sister, Denise Townsend, confirmed that he will have a job when he's released. In addition to having full-time employment, he hopes to work for a nonprofit as a mentor. In the future, he's interested in obtaining his CDL license and opening his own barbershop, as mentioned earlier. He will continue to seek medical treatment when released, and according to his attorney, Precious Blood Ministries agreed to assist with mental health, education, professional workforce assistance, substance abuse, and housing. Mr. Guerrero has excellent family support. 9 members were present for his interview, and his mother and sister spoke of their willingness to assist him in adjusting to their community, and they spoke of their love for him. We have some opposition to parole release, including the Cook County State's Attorney, who opposes the granting of parole in her letter of May 21st, 2025. She takes the position that given that Mr. Guerrero takes no responsibility or accountability for the violent crime he committed and the life he took, she feels there's a substantial risk that he will not conform to the reasonable conditions of parole. And she said that granting him parole would deprecate the seriousness of the offense, promote disrespect for the law, and have an adverse effect on institutional discipline. A letter from Marco Alves sent on March 14th, 2025 states that he's the deceased cousin. He explains that the deceased was 16 years old when he was murdered. He describes his and his family's grief and believes 20 years is an inadequate time to serve for the murder. He asks that the board deny the petition for parole. I would note that this is this board's first consideration for parole for this gentleman. I would then move that we go into closed session.
Aye.
Ms. Tyson, are you ready to continue? Okay. Do any of the board members have any questions at this time? Seeing none. Ms. Davis, you want to make your presentation and introduce yourself and your witnesses? Yes, you need to be sworn in first.
Mr. Guerrero, I'm going to be swearing you in as well. Can everyone please stand and raise your right hand? Do you solemnly swear or affirm that the testimony that you will give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good morning. I am Cherie Davis, and I represent Mr. Guerrero. It is a pleasure to be before you all again today. For the most part, the petition was presented perfectly. I just have some things to just update and to clarify. So, as for the criminal record, which most of it, of course, was discussed in closed session, the major thing that I wanted to point out, the criminal history is kind of convoluted and confusing, but essentially there were multiple arrests for really petty offenses that involve survival needs, but then also just joyriding and things that kids do under little monitoring. And the significance of his juvenile criminal record is that you've heard that around 9 or 10 he was sexually molested. He also was taken from his home, and then his mother was also incarcerated. And at that point, he literally began to wander the streets. And he himself became addicted to drugs. And then this is where these multiple arrests started to happen, and he was picked up and he was let go. It didn't lead to many formal charges, but there was some contact with law enforcement at that time. Ultimately, he ends up in prison for the murder charge, but nothing prior to this. There were any crimes of violence or any other exhibits of violence and malice towards any individuals. And then, of course, as to, again, and just in the same vein of talking about behavior, I do want to talk about the tickets that were discussed. In 20 years, this kid who had multiple police contact as a juvenile ends up in prison for murder. He gets into prison, and in 20 years, he only has 7 tickets. 7 tickets, even with some of them that, you know, we see many times when people go into prison, there is a stage where they become acclimated with the space. There was some conversation about a potential gang affiliation, and so just being able to maneuver in that space with all of those pressures and thoughts about protection. Now, as it relates to gang activity and these tickets, Mr. Guerrero was somewhat forced into gang activity. He was inadvertently jumped at the command of his cousins, jumped into this gang, and they did so because he was seen as weak. He was bullied all the time, and he was affiliated with gang members and not on their watch. That wasn't happening. And so his affiliation was not necessarily by choice, but what it brought him, he did embrace. It gave him brotherhood. It gave him a place to belong. And when he was incarcerated, the ticket that was mentioned on September 2014 involving gang and unauthorized organization activity and contraband, that was actually due to papers being given to Mr. Guerrero while in custody of how to conduct himself in the prison and align with how the gangs conduct themselves. And that was found in his cell. As it's written, gang activity organization, but this was someone essentially giving him the law of the land as it relates to gang activity, and Mr. Guerrero, in his naiveness, it's laying around and he's caught with it. Then the dangerous disturbance mentioned in 2015, a gang and unauthorized activity, and it talked about fighting. This fight was over the phone. Someone snatched the phone from Mr. Guerrero, and he was jumped. And then others jumped in to help Mr. Guerrero, and it was labeled as gang activity again. Now, seeing it, there's one interpretation, but the nature of the circumstances and how things are noted and documented, I feel that it was necessary to clarify that. Now, some of these things, the sexual misconduct, again, on his face is terrible. I talked to Mr. Guerrero, and essentially he's in the shower and he is exposed, and female officer is privy to that exposure, and it was a very awkward situation, but it wasn't a deliberate attempt to make her uncomfortable, but he was exposed. And then disobeying a direct order. Most recently, Mr. Guerrero was in a working cell in a new job that he hadn't worked before. And in practice, I guess there's some issue with like light exposure. He put a sheet over his bunk like everyone else does to remove the light, to shield himself from the light, sorry. And it actually is a violation to do so. He wasn't aware of that, and in practice, others were doing it as well, but he was asked to take it down, and he took it down without any harm or foul. Now, outside of this, you all did receive letters, and I think it actually was submitted in the certificate pile, where one of the officers, Officer Pollock, actually offered that, you know, Mr. Guerrero follows the rules to the best of his ability. He very rarely has to be redirected, and he takes full accountability for the things that he has done wrong or his missteps or his misinterpretation. He's done that from his juvenile experience until and all through his stay within prison. Now, from there, we know that he does maintain his innocence. And I know that there's a lot of communication and comments about that he shouldn't be released or he's a risk because he won't take accountability. And quite frankly, it's unrealistic to ask someone to take accountability for something that they did not do. And now we've heard information today about the nature of that initial conviction. We've heard about how Mr. Guerrero exercised his right to go to trial. And prior to that trial, there were statements that were obtained through precarious circumstances, and they were through coercion, and there's a civil suit that was settled right before his trial based on how these statements were taken. And those witnesses then went to trial and got on stand and said that they were forced to give those statements. And so Mr. Guerrero is not claiming his innocence and just for happenstance. He's not saying, oh, well, I'm the victim here and there's no reason to convict me just because the circumstances on which this conviction came about are under scrutiny. And yet here we are. And so you take all of those things, and this individual, Mr. Guerrero, has sat in prison for over 20 years for a crime that he did not commit, that he has continuously spoken to his innocence. And think about everything else he had already gone through before this happened. He had no place to go home, to call home. He was homeless. He lived in a single-parent home. His mother was a drug addict. She had men in and out of her home on multiple occasions. One of them molested him. She went to prison, leaving him abandoned, wandering the street. He had to survive and try the best he could with what he had. He had multiple encounters with law enforcement for petty things. They picked him up, let him go. And every single time he took accountability for that, even for this murder, he wasn't present. He wasn't present, and yet when his family called him and said, the police are at our home and they're looking for you, he didn't run away. He didn't hide. He went straight to the house. He was immediately placed in handcuffs, and he's been in custody ever since. This is not an individual who is trying to circumvent any accountability for what he's done. He's taken accountability for what he has done. And he maintains his innocence because he didn't do it. And even still, with carrying the weight of all of that, Mr. Guerrero has followed instructions in prison. Mr. Guerrero has made use of everything he possibly could. When he wrote his petition, he was in a state of hopelessness because he had tried and wrote multiple times to get access to education because he knew he needed a GED to do the thing he wanted to do, which was cut hair. He couldn't get it because of how he was classed. Then he couldn't get it because of COVID, but he kept writing so he wouldn't be forgotten. And now he's in those classes to prepare to get his GED. He was at the bottom of the list to get jobs, but he kept applying. And when he showed up and he did the job, he was an exemplary worker. He kept getting jobs. He had a worker's job when he got a ticket, and he was following the rules. You have officers speaking to his character, and, you know, it says a lot about a person who, even though he maintains his innocence and he believes that he shouldn't be in here, he still maximized what he had. He couldn't read or write when he went into prison, and you know what? It was enough times of somebody reading a letter for him where he said, enough is enough. The only way I'm going to be accountable for myself is I'm going to figure it out. And when you hear him speak today, when you hear him read today, because there are some portions that he's going to read, think about that. This kid was diagnosed with ADHD at 7, learning disability, bullied for being the slow kid. But he's not the slow kid anymore. He's a grown man who can read, write, and speak and articulate and advocate for himself. He has incredible support from his family. You heard about them showing up on the screen. They are here today. They could raise their hands and just kind of wave at the board. They're even coordinated. I don't know if they meant to do that or not. I should have wore a white shirt, but they're coordinated. And their support doesn't just go for physical. They showed up on that screen. Since we talked on that screen, I've had requests. I've had questions. Raphael has a very detailed parole plan, and he has communicated with his family about every step, from I need documents in order to get my job and what those documents are. He knows that he needs to have a GED in order to get his barber's license because he wants to be a barber, and obviously you have to have a license. So we've connected him with Precious Blood to be able to get assistance with the education. He wants to get his CDL, so he's got a 6-month plan. His cousin, who you'll hear from, has opened up her home to him. That she has renovated her place to give him his own space to live. He has clothes. They're supporting him financially, transportation. He has a job already for contracting, and as many contracting programs he could do, he's done. He's got multiple certificates that you all have for just different contracting jobs. Now, it's in theory, but he's passing it, and he's excited to get out and actually put it to use. And this individual, despite everything that he has gone through and every moment where he felt like someone failed him or let him down or didn't listen to him, look at him now. He has defied the odds. And so I do want you to hear from his sister. I'll reserve my any other commentary for closing, but I don't want us to get distracted by the idea of accountability to a crime you didn't commit. Mr. Guerrero took accountability for the person, the child, and the circumstances that he had before this happened, and he made a decision to do something different and be someone different, and that is the person that we are discussing today. Thank you.
Hi, my name is Daniela Guerrero. I'm Rafael's cousin, actually. We grew up really close together. We're a couple of months apart. We're still very close. I was extremely nervous to get up here and speak. They actually had to push me here into the seat, but I'm doing it for him, and I'll do way more for him. We're prepared, to get him back into society, where we want to make sure that you understand that Rafael is the victim here today. In our eyes, he was taken away from us 20 years ago for something that he did not do. We love him, we miss him, and we need him back. We're ready. We're ready. It's time. God set you here for us. This is the time. You guys will see that he's innocent. If you look in his paperwork, he's innocent. I don't know how this happened to him, but we're going to stand strong with him. We're prepared to go with him whichever way this goes. If you guys don't let him out, we're going to be with him for the next 7 years. We're going to stand strong with him. We're going to wait for him, and we're going to do what we said we're going to do when he gets out. And if you guys let him go today, we're prepared to do that today. Whichever way it goes, we stand with him. We love him. Ralph, be strong, Ralph. God got us, you know. Just keep our faith, and these people know that you're innocent. It's about you today. Give him back to us. You know, he was taken from us. He's innocent. The justice system let us all down. I'm sorry. No disrespect to none of you guys, but it has. And he's going to be with me and my kids. I have 3 boys, and Rafael is going to be a great example to them. I'm going to expect him to be there for my boys as he is now, even where he is today. He's there for us emotionally and mentally all the time. He's worried about my kids' grades and how they're doing. He loves the way I'm raising them, and I just want him to be a part of that. He deserves everything. He deserves the world. He never did nothing to nobody. And we stand with you, Ralph. We love you, and it's time. I know it is.
Okay, thank you for your testimony. I think we'd like to hear from your client now, and then we'll open it up for questioning.
Good morning.
Okay.
Can you hear me?
Yes, we can hear you.
Good morning. My name is Rafael Guerrero. I'm 37 years old. About to be 38. I was incarcerated at 17 years old, not knowing what jail or prison was going to be like. I'm not sitting here telling you that I was an innocent person in the streets. I take responsibility in that. And I'm looking for a fair chance. I have a place to come to. I have support system. I have a job waiting for me. And I would like to continue doing good on the outside. And I want to get started now with the blessings from you guys. I know I was not perfect. I was not perfect growing up. I wish I was. But I was involved in gangs. I was involved in that stuff. And that's like, I don't care for that stuff anymore. I care for my family. I care for myself. I didn't know how to read or write when I came to prison. But my sister, rest in peace, who is with me today, believed in me. She always believed in me. And just hearing her in my head telling me that everything's going to be fine, to just believe in God. And when I started believing in God and taking that next step, is when everything started changing for myself. I'm sorry. If it's fine with you, if I can just read something. Can you guys hear me?
Yes.
want to express my deepest sadness and sympathy to the friends and family of Mr. Diaz. Although I maintain my innocence, I understand the pain and the trauma that senseless gun violence causes to families like Mr. Diaz. I too have lost friends and family members to violence, so I know the pain and suffering that it causes. When I look back at my childhood, I know that I was not a perfect kid growing up and lived a life that caused me to make some bad decisions that I am not proud of. Growing up, excuse me, nor will I ever be. But I stand here, but the teenager I was then is not the man I am today. I think about how I grew up with no father or big brother, no one to look up to. I didn't attend school. I didn't know how to read or write. My parents weren't active in my life to teach me any morals or domestic training at all. I come from a community where these issues are unfortunately common among teenagers. The influence where it is at its highest capacity to drugs, gangs, and violence, giving me no choice but to adapt to this type of environment. As a kid, as a man now, I believe I was fooled. I was fooled by this crowd. I was blind to my actions and in the worst emotions. But I stand here today blessed and thankful. I have been incarcerated for 20 years. For 20 years now, and throughout these hard times, I have gained so much knowledge and experience that put me in great position for society. I have changed and now possess the qualities that I can use to help the younger generation from making the same mistakes. I have made up my mind and told myself that I'm going to be a mentor and try to work with nonprofit organizations to do my part for my community, which I'll call God's plan. Since my stay here in IDOC, I have had the opportunity to gain certificates from life skill to roofing to Bible study, forklift and hospice, and serve as a sanitation worker. Nothing feels better than achieving in life, and I want to continue feeling that same pride and success outside of these suffocating walls. The day I get released from prison, I will continue to be a law-abiding citizen. I am no longer the teenager that I entered the jail at 17. No more gangs, drugs, just a man trying to start my own family and work and being better every day. Along with mentoring, I would like to go back to school, get my CDLs, GED, and work hard every day. Hopefully someday own my own business like I always dreamed of. I want to thank my family for all your love and your support. And to my mother for never leaving my side. You did the best you could, and I just wish I was a better son to you. Sorry for all the pain I caused you. I promise I will do my part to be a better son and a role model to my nieces and nephews, someone you all can be proud of. As I depart myself from this hearing today with relief and resilience, I pray for peace for the families of Mr. Diaz and everybody that was lost to gun violence. Thank you for your time and your consideration. God bless you.
Thank you, Mr. Guerrero. Is there any questions from the board at this time?
I have some. Ms. Davis, were you the attorney at the resentencing for Mr. Guerrero?
No, sir.
I don't know if you're familiar with the record from that resentencing, but if you are, I'd like to know what position Mr. Guerrero and his attorney took regarding what the sentence should be.
No, actually, we've tried on multiple occasions to retrieve the transcripts. We finally reached someone that said that they'd mail them to us, but we never received them.
Okay. And do you know at the trial itself what was done by Mr. Guerrero and his attorney to present to the jury that the statements made implicating him had been recanted, and the jury, in spite of that, rejected those? Is that what happened?
So there was a motion in limine to be able to keep those, any talk about any settlement or any of those things out. The parties were able to talk about the circumstances surrounding the testimonies and or the statements that were taken, but it was very limited in scope, and there were multiple times where supposedly defense counsel tried to say that the state opened the door and the court wouldn't allow it. But the witnesses did get on stand and they did recant under oath, and they also stated the circumstances on which their statements were procured, and they, even to the extent that they did not write the statements were presented to them and they just ultimately signed them so that they could go home.
Okay, so the jury knew that and then obviously convicted him in spite of their recantation.
Correct.
Okay.
Essentially.
What steps have been taken to pursue this wrongful conviction or the claim of innocence since? What have you done to pursue an innocence position in the courts, if anything?
So myself, none. Mr. Guerrero had filed a couple of post-conviction motions. He also had gained new information about who potentially had done this, because once he was taken into custody, the community started talking, and an individual did say that they'd done it, but it was written off as that it wasn't new information. So, I mean, that's the gist that I had, that it wasn't new information. And so it was denied. But he tried to offer up new information as it was presented to him. He's tried to give as much information about the circumstance around it. He also, I'm not sure where the allegations are from that he encouraged people to change us or say anything. He never got an opportunity to communicate with these individuals. This is information. Their statements were information that he found out while he was in custody, and I mean, to the best of his ability with what he had, he tried to communicate that to the court. So,
thank you very much. I appreciate it.
Any other questions from the board members at this time? All right. Seeing none,
I'm sorry.
with the clerk.
Also, his cousin just made me aware that his paperwork has been dropped off to the Innocence Project, so it's still.
We just haven't had any response yet. We were hoping by the time he.
Okay. Hearing no questions from the board, we will let the Cook County State's Attorney's Office speak. And if you know anything, evidence on the resentencing, any what was said, we'd appreciate hearing that as well.
As far as the resentencing, I would note that our staff has attempted multiple times to get that transcript. They've worked hard over the last month, and they were also told it was in the mail or being sent. We just haven't been able to get that.
Cook County.
Good morning. My name is Courtney Quam, and I am a Cook County Assistant State's Attorney. Our office does oppose parole in this case. To start with, I can provide a little bit of clarity. So Mr. Guerrero did file a post-conviction petition in January of 2012 alleging actual innocence. This petition included his own affidavit as well as the affidavits of Juanita Guerrero, Daniela Guerrero, and Eladio Guerrero, as well as Danny Martinez. This was reviewed, read by the circuit court, and the circuit court denied his petition. He then appealed that decision. He did not present his actual innocence claim on appeal. He just presented his ineffective assistance of counsel claims. That appeal was denied. The appellate court also reviewed the alleged other person, the Saul Rodriguez, who they reviewed his statement. They reviewed the statements by Mr. Guerrero's family members and concluded that Mr. Guerrero is the one who committed this crime. Mr. Guerrero also filed a successive post-conviction petition in 2018, which was denied, and the petitioner appealed, Mr. Guerrero appealed that decision as well, and that was when he was remanded for resentencing. And during resentencing, he was resentenced to 28 years imprisonment after the court heard arguments, and that was the sentence that the court determined was appropriate in this case. Most importantly, accountability and rehabilitation is not something that we cannot discuss in our criminal justice system. That is the goal of what we are trying to do. You have to take accountability for what you've done. That is the first step to rehabilitation, and Mr. Guerrero does not do that. And his disciplinary history exemplifies that he will not conform to the reasonable conditions of parole. He received major tickets after being resentenced. He committed a very serious, violent crime that he takes no accountability for, no responsibility for, and he has not demonstrated any genuine rehabilitation in that aspect. And any rehabilitation he has engaged in is therefore negated by that, missing that very important, most important step. Accordingly, the Cook County State's Attorney's Office opposes parole in this case. Thank you.
Any questions from the board members for either of the two sides? I have one. You said that he filed some post-conviction petitions. Are they still pending at this time?
I'm not sure. I believe that the ones that have mentioned are the ones that I'm aware of that he attempted to do on his own. But I guess whatever the Innocence organization is pursuing may be something different. But Mr. Guerrero has attempted to do these motions pro se, as you heard of just some of the formalities that he ran into. But otherwise, I don't know or believe that anything is currently pending right now.
Can I answer to that?
Okay. Do you have something to say, Mr. Guerrero?
Yes, sir. Can I answer to that? So I don't have nothing in court right now, or any petitions or nothing like that in court.
Thank you.
Thank you.
You're welcome.
Is there any more questions from any of the board members? Seeing none, Ms. Tyson, are you ready to present your motion?
May I have an opportunity to give closing?
Sure, go ahead.
Okay. The opposition from Cook County, the comment about taking accountability for what you've done, absolutely agree. You should take accountability for what you've done. That's been Mr. Guerrero's position for as long as he's known. He's taken accountability for who he was, the circumstances in which these things happened, and he doesn't shy away from that. And so encouraging someone to take accountability for what they've done, absolutely. But we are in a situation where Mr. Guerrero is being asked to take accountability for something he did not do. Now, however, it wants to be received by the county. There has been a trial. He's accepted the process of due process. He's had his day in court. He has used the resources he's had available to him to file post-conviction motions with the information that he has, whether the dismissals are on merit or a formality. He has respected the process of due process. He has shown remorse for just the circumstances around what has happened to Mr. Diaz, but he can't take accountability for something he did not do. And with that being said, when we're considering whether or not there's a substantial risk of noncompliance with parole, there's no substantial risk that Mr. Guerrero would violate parole or aftercare conditions. He's only had 7 tickets in 20 years. We've talked about that. He's participated in numerous rehabilitative and educational programs. Anything he had access to, he participated in it. And to the extent that he could be specific about trades and things of that nature, he pursued those things. He even won a soccer tournament and a basketball tournament. He realized not only is he enjoys competitive sports, but he's good at it. He took advantage of everything he could do, and he earned the trust of staff and his peers. He got jobs. He also had a letter written by an officer who watched him remain in compliance. He's built a strong re-entry plan involving housing, supportive family, job placement, assistance from local nonprofit. I've attached him to some. There's an individual here, if he could raise his hand. He represents a nonprofit organization who wants to partner with Mr. Guerrero to have access to the community and help with social work to keep people out of gang activity. That's on Mr. Guerrero's list of things he wants to do, and we found someone who's willing to do that. He's also going to get mental health support. He's come a long way, but he's got a long way to go, and Precious Blood has agreed to help him with that as well. His record of institutional conduct shows that he respects authority to the best of his ability with the information that he has, and he's fully capable of thriving under supervision. Even while maintaining his innocence, he has never been disruptive. He has not been bitter. You have multiple letters from his family and friends that know him that says he's always in good spirits. He's always encouraging other people. They're trying to wrap their mind around how he's not melting down and losing his mind considering the circumstances. He hasn't been disengaged. He's been very engaged, advocating for himself with what he has. He has exhibited emotional maturity. He has exhibited responsibility and a desire to contribute positively to a society upon his release, even though his society failed him. He has thanked his mom, and he has apologized to his mom, someone where the circumstances in which he was raised, one could have said, why, oh, you failed me. He said you did the best that you could, and I wish I could have been better to you. As to the seriousness of the offense and respect for the law, let me be very clear. We do not minimize the severity of the underlying offense. Any loss of life or harm to another person is a tragedy, and the law must take that very seriously. But parole is not a retrial. Instead, it's about evaluating who this person is today and whether continued incarceration serves a rehabilitative, deterrent, and public safety function. And Mr. Guerrero's consistent claim of innocence is not a rejection of the law. It is a plea for justice, which he will continue to pursue. He's never shirked the rule of law. He has respected it, even as it failed him. He has never attempted to evade the rules. He's never attempted to retaliate. He's never attempted to cause harm to anyone during incarceration. He's shown restraint and grace despite the overwhelming weight of a conviction in which he feels is misplaced. And he's reflect a deep internal discipline and respect for due process. The irony of that. And so granting parole here would not promote disrespect of the law. It would honor the legislature's intent to offer second chances to those who have shown growth, who have, regardless of whether or not they've confessed guilt. And then the effect on institutional discipline, there's no basis to believe that, Mr. Guerrero's release would have a substantially adverse effect to institutional discipline. He's been a mentor. He's been in conflict resolution. He's worked up his literacy. He's participated in team sports. He's been very persistent in communicating to get the things that he needs. He's only engaged in violence after he was jumped. he defended himself. He has not taken part in any organized disruption, and he is regularly trusted with responsibilities by staff. His release would simply affirm that the correctional system recognizes growth and recognizes maturity and emotional regulation, and putting people in places where they can be trusted and they can thrive. It also recognizes character development, which he has been very persistent, over 11 certificates in that. Rather than undermining discipline, his release would incentivize good behavior. He's worked hard. He's worked hard in spite of, and kept a positive attitude. And he's also adamant about paying it forward, contributing to society. You heard he donated $200 of his own money to the homeless while incarcerated, and he's already talking about what he can do for others with what he's been through and endured once he's out. And so, in conclusion, Mr. Guerrero entered prison as a teenager. He was tried and convicted based on statements that the very witnesses disavowed under oath, and the statements that were procured under highly suspect circumstances. He has now served 20 years. He's matured into a thoughtful, productive man and upheld a standard of behavior that aligns with every principle of rehabilitation. He does not present a danger. He does not disrespect the law. And he certainly will not disrupt institutional order. And he represents the kind of person this statute was enacted to support: a young man who has served his time with dignity, and who is now ready for the opportunity to live freely and contribute to his community. He has worked hard for it. He is determined to continue to work hard for it. And I myself am blown away at his resilience and his disposition in spite of it all. And so today, I ask you to grant parole to Mr. Guerrero. Thank you.
Thank you. Ms. Tyson, are you ready to make your motion?
I am. Mr. Guerrero clearly had a difficult childhood. He lived in a community with drugs and violence. Even so, after incarcerated, he taught himself to read and write, which is certainly to be commended. He's taking basic education classes. He hopes to qualify to take a GED. He's maintained strong family relationships. He has a place to live. He has a job upon release. He says he's no longer the 17-year-old youth who was irresponsible and influenced by gang members. While all these factors in a well-developed parole plan weigh in favor of granting him parole, this board also has to consider the severity and nature of the offense of his conviction, whether granting parole would deprecate the seriousness of the offense, and whether he would comply with the terms of parole. Mr. Guerrero was found guilty of shooting a 16-year-old 6 times while the victim was trying to run away. He takes no responsibility for the murder, and his disciplinary history is concerning, especially so the July 24th ticket for gang activity, which resulted in a disciplinary transfer. I also note that he received the benefit of a resentencing hearing when his sentence was reduced from 53 to 28 years. My motion is to deny parole.
Do we have a second?
I'll second.
Mr. Grubb seconded. Motion's been made and seconded. Would you please take the roll?
Ms. Tyson,
Yes.
Mr. Boland,
Yes.
Mr. Coates,
Yes.
Ms. Globoker,
Yes.
Mr. Grubbs,
Yes.
Mr. Heaton,
Yes.
Ms. Schaffner,
Yes.
Ms. Taronis,
Yes.
Mr. Tupy.
Yes. By a vote of 9 members voting yes, the motion to deny parole is approved. That concludes the hearing at this time. Let's take a 5-minute break to have everybody moved out and recoup.
Check 1 2. Check 1 2 1 2 1 2 2 2. Check 1 2.
All right, are the board members ready? Why does... Hello? Hello? Doesn't. Hello?
Yes.
Hello? Are we ready? Are the board members present? Where'd Coach go? Oh, he's hiding over there. The next case we're going to call is Anthony Riley, which is Ms. Taronis' case. So, Ms. Taronis, are you prepared at this time?
I am ready when you are, sir.
All right, go ahead and proceed.
So is that Dr. Quintana? Okay, just want to make sure. All right, okay.
We're going to have everybody sworn in and then call the next case and then swear in the witnesses.
Could the front two tables please stand?
Stand.
Oh, sorry. Do you solemnly swear or affirm that the testimony you will give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank
Yes.
you.
Okay. Witnesses have been sworn. Mr. Ronas.
Thank you, thank you. Thank you for everyone today, and good morning again for being here in support of Anthony Riley, his team, as well as family members. I see that you are all back there. Thank you for continuing to accompany him in this journey of accountability and gratitude. Okay, let's get started.
Mr. Taronis, can you move your mic down a little bit? Just
Better?
That's better. Thank you.
Okay, all right. Okay. Anthony Riley, Mr. Riley. He is presently 38 years of age. The crime occurred at the age of 17. Mr. Riley, at the time of the meeting with him, was accompanied by his attorney, Counsel Lindner from the Illinois Prison Project, Dr. Elena Quintana from Adler University, an author of the psychological evaluation that you reviewed in the packet, along with all the testing, his sister Angela Riley, I hope I pronounced that correctly, Brian Johnson, who's affiliated with the Illinois Prison Project. Mr. Riley was prepared and eager to share. It was difficult to hear since the institution required by protocol to sit away from the computer that day, so I did my best and he did his best to communicate. Mr. Riley is here today respectfully requesting grace from the Honorable Board to support his return to community earlier than his MSR based on his rehabilitation, low risk to community, setting a good example to his fellow returning citizens, and continues to do well and maintain that behavior, and has met over 20 years of accountability as a youth offender, not deprecating the law. This is his request. Mr. Riley and counsel were asked to confirm the information in the application if it remained accurate and true, and they affirmed. Additional information would be submitted to support the application initially submitted. So you should have about 3 documents, 2 supplementals, and an initial application that inform and will inform your decision. I want to make sure you received all that, board members. The offense committed was murder. He was arrested in November of 2004. He was sentenced initially by jury trial to 50 years in Cook County. After a sentencing hearing, the court sentenced the prisoner to 50 years as indicated, but presently he's serving 25 years for the murder because he was resentenced in April 13, 2023, and given time credit served of 6,724 days. Statement of facts. Sorry, my computer's not cooperating here. Okay. On November 20th, at the location of 144 West 57th Street in Chicago, the defendant, Anthony Riley, pulled his car up to the witness car. The defendant and his friends and the witness had a prior fight, and they were talking. As they were talking, the victim came walking up to talk to the witness. The defendant took out a gun and fired at the victim 4 times. The defendant shot the victim in the face, killing him. The defendant had someone else drive his car home and park the car behind the house. The police found the defendant hiding in the closet with the murder weapon. The defendant gave a videotaped statement to the police and assistant state attorney. He was 17 years of age when he committed this offense. These are the statement of facts by the assistant state attorney document. Mr. Riley does not have a past criminal or juvenile record. This is his first offense in harming the community. The litigation on this case is pretty lengthy. I know you have the assistant state attorney file and correspondence, but I think it's important to read into the record as this is a public hearing, so I'm going to take that opportunity for you to hear that information. So this is the appellate and post-conviction history. The appellate court affirmed the petitioner's conviction on direct appeal on October 28th of 2008. And the Illinois Supreme Court denied the petition for leave to appeal on January 28th of 2009. On April 12th of 2010, the petitioner filed a pro se post-conviction petition alleging that his trial counsel was ineffective for 1, failing to investigate and call intra-ally Andre Clifton to support his claim of self-defense, where Clifton would have testified that he removed the gun from Marcus's person after the shooting. 2, failing to support the self-defense theory by presenting evidence of Marcus' prior conviction for unlawful use of a weapon. 3, not calling any witness or presenting any evidence at the pretrial motions to quash arrest and suppress statements. 4, failing to investigate and present evidence of Marcus's violent reputation as a gang member. And 5, failing to investigate Marcus's cousins to discover their violent reputations in the neighborhood and their potential to lie about Marcus not having a gun on the night in question. The trial court summarily dismissed the petition, and the dismissal was affirmed by the appellate court on April 23rd of 2012. On March 18th, 2014, the petition filed a pro se motion for leave to file a successive post-conviction petition, asserting various claims of ineffective assistance of trial and appellate counsels. The petitioner also argued that he had newly discovered evidence of his actual innocence, namely the affidavits of Romario Morgan and Audrey Maxey Sr. The petitioner argued that these two independent witnesses would testify that they observed Marcus carrying a gun at the time of the incident and corroborated his claim at trial that he shot Marcus in self-defense. On June 16 of 2014, the trial court denied the petitioner's leave to file a successive post-conviction petition. With respect to the petitioner's actual innocence claim, the trial court found that the affidavits of Maxey and Morgan provided only cumulative evidence that would not have changed the outcome of trial or the initial post-conviction proceedings. The petitioner appealed, and the appellate court reversed the judgment of the circuit court denying the petitioner's leave to file a successive post-conviction and remanded the case back to the circuit court. On July 20 of 21, the petitioner through counsel filed a successive post-conviction petition pursuant to the appellate court's remand. February 2023, he filed a supplemental to his post-conviction petition. And then on April 13, 2023, the petitioner was resentenced to 25 years imprisonment and given credit as indicated earlier. July of 2024, the petitioner submitted a petition for executive clemency for a non-public hearing, and that is still pending. The state attorney did provide a letter for an objection, and they indicate that parole is a matter of grace and not of legal right. A convict cannot evoke it as his own will and has no right to demand that he be discharged before the expiration of a maximum term of his sentence. Granting Mr. Riley parole at this time would deprecate the seriousness of the offense and promote disrespect for the law. Mr. Riley was resentenced by the trial court in April of 2023 in consideration of the fact that he was 17 years old at the time he shot and killed Marcus Murphy. When resentencing Mr. Riley, the court also considered the institutional adjustment, rehabilitative efforts, and expression of remorse, and after hearing testimony, determined that 25 years of imprisonment was the appropriate sentence in this case. And my mouse is not cooperating, sorry, thank you. I'm not going to share with you the petitioner's version of events. It's lengthy because he has to set the tone for why this occurred. One night, Mr. Riley attended a party with some friends. To this day, he does not understand why he went. A self-described introvert, he rarely attended parties. While he was there, an argument broke out and it escalated into a brawl. Mr. Riley and his friends tried to break up the fight, but resentments remained afterwards. In the days that followed, the shooting on Mr. Riley's block continued. Mr. Riley specifically remembers an incident where his brother Alfred and his young family were driving down the street past his grandmother's house. Immediately after they turned the corner, Mr. Riley heard the unmistakable sound of close gunshots. For one devastating moment, Mr. Riley was sure that he lost Alfred, the big-hearted brother who doted on him, who encouraged him, and who protected him from the world. Then he saw Alfred's car driving back around the corner. The car was marked by bullet holes, but miraculously no one inside was injured. Still, Mr. Riley was shaken to the core. In his mind, if the person who protected him from the world wasn't safe from the violence, then nobody was. After that day, he began to carry a gun. It was so easy to get access to a gun, he remembers, and shaking his head. The day after Alfred's car was shot at, Mr. Riley was in a car with some friends. They passed another car, and Mr. Riley recognized its occupants as people who had been involved in the fight at the party a few weeks before. Mr. Riley and one of the occupants of the other car, Taya Martin, had just learned that they were related, and they agreed that that was a reason enough to resolve whatever resentments remained after the fight. The two cars pulled up next to each other to discuss resolving this conflict. In the middle of this discussion, an occupant of the other car exclaimed, "M. Murder, "What are you doing here?" Mr. Riley was familiar with the M murder, or Marcus Murphy. Mr. Murphy had told people that he did not like Mr. Riley, in part because of a dispute over a young woman they were both interested in, and in part because he was friends with some of the people involved in the fight at the party. Mr. Riley had heard that Mr. Murphy was after him, and also heard that Mr. Murphy had a gun. He even knew that Mr. Murphy was on house arrest for a gun case. Mr. Riley was terrified. Someone in the other car said, "There goes M murder." Mr. Riley looked into his rear view mirror and saw Mr. Murphy emerge from the dark, walking towards the back of Mr. Riley's car. Mr. Riley thought he saw Mr. Murphy reach under his shirt and into his waistband. He was sure Mr. Murphy was coming after him. He ducked, grabbed the gun he'd been carrying since the day before, pointed it behind him, and shot 3 times as he drove away. There are 6 institutional tickets, and they're well documented in the application of the petition. Mr. Riley provides a description of each of those tickets, articulating his story, and counsel further documented his information. The first one was May 24th of 2011 for contraband, unauthorized property. He received a verbal reprimand. Okay, maybe I'll use this mouse. Sorry. The second was in April of 2016 for disobeying a direct order. September 6th of 2017, dangerous disturbances, gang or unauthorized organization activity. December 8th, 2019, electronic contraband, giving false information to an employee, contraband, unauthorized property, violation of rules. September 4th of 2020, damage or misuse of property, contraband, unauthorized property. June 29 of 2021, dangerous disturbances, disobeying a direct order. The 2021 is his latest institutional ticket. There aren't any others as indicated in the application and requested. The reason of seeking relief, Mr. Riley was 17 years at the time of the offense. Mr. Riley has rehabilitated himself through deep reflection, education, hard work, and acts of service. Given that he has already served decades in prison for a crime committed when he was a juvenile, getting him parole would serve the interests of justice. This is a statement by his counsel, his attorney. He has demonstrated some positive behaviors and contributions for self and for others while he has spent his 20 years in IDOC. Many of his accomplishments have been programming that he has taken the initiative to access due to the limited programming made available to returning citizens when they have a long sentence to serve. Some of those significant accomplishments are his high school diploma, which he completed when he was in Cook County Jail, but that was conferred by DuSable High School. They authorized this high school diploma through a partnership with York High School. Mr. Riley has really demonstrated courage, and I say this because many of our returning citizens have limited access to mental health. I'm not going to talk about his mental health issues, but I want to share how he's taken an initiative to pursue therapeutic interventions to process the life-changing decisions of taking the life of another. He knows if he works on self, it will impact all of those around him. He has put his brokenness to work to heal and serve generations to come. He has earned a good number of programmatic certificates because he also is in a state of mental health wellness and has continued to participate when given the opportunity to continue to sit in counseling groups with his fellow peers. And all these activities are a result of his ongoing commitment to improve his thoughts, behaviors, and overall mental health. And this is also reaffirmed and stated in the psychological completed by Dr. Quintana, who will share with you also a concise summary of that psychological. Mr. Riley has also increased his knowledge by accessing legal opportunities. Now, this is important as we continue as individuals to access wisdom to inform our decisions. While incarcerated, he has accessed all the legal portals necessary to address his case. He has taken individual responsibility with that knowledge to complete pro-social applications for his resentencing hearing and other legal positions he has taken. One important personal advocacy measure he has taken is to strengthen his relationship with his family. As family is a very strategic strategy for all of us to strengthen, to give us the support necessary as we continue to maintain and sustain the learning. Mr. Riley's intention to focus on nurturing his immediate family and extended support demonstrates his ability to embrace family and an important value supporting progress through loving accompaniment. The family remains connected through visits and their expressed verbal commitments upon return to the community. Mr. Riley understands the value of family and its unwavering support. He has become more conscious of his behavior and to be more intentional of the impactful change they can have. His reentry plan. You know, we hear of many of our community partners who are credible messengers and accompany many of our returning citizens. And it's great to have them on paper saying we are going to support and help. The difference here with Mr. Riley's application is that our community partners have started connecting with Mr. Riley while in institution to remind him of his responsibility, to his accountability to the offense, and to his development. So they have reached out and continue to support his programming and will continue to do it as he returns, if that is the grace that is given by this body. For housing, St. Leonard's has provided a letter and has indicated that they are willing and have a space available if he is released. He also has the support of his family, his sister, who will also provide support as needed. Mr. Riley has also indicated that he will work with the mental health agencies that are ready to prepare and continue to serve, like NAMI, Precious Blood. Precious Blood has already started having many conversations with him while he is in the IDOC facility. His family continues to visit and stay connected with him. Very important factors when you're in institution, and those relationships with community and family will continue to exist when he returns. And as we know, the Illinois Prison Project will continue to provide services as needed and also walk with him in any area that is needed. Dr. Quintana has also provided some additional agencies located in the west side of Chicago, like Walls Turn Sideways, to support with peer support, and also People's Liberty Project, which will provide additional peer support and mentoring. I want to touch a little bit on Dr. Quintana's psychological report very briefly, but she will also share with you any necessary testing to talk about risk, reintegration, programming, and such. Her psychological report documents validated testing to support Mr. Riley as a low risk of reoffending, presenting him as an example to others, an institution of values, of true rehabilitation. He continues to support a life of wellness, which is courage, self-discipline, justice, and wisdom. She notes he has completed over 20 years of his 25-year sentence and testifies that the time completed does not deprecate the law due to the manner in which he lived his life in institution and his commitment to self and community upon return. Board members, I know you have read the report, but Ms. Quintana will be available for questions and further clarity. So that is the end of my report. I will continue to add or answer any questions, but I'd like to turn your attention to council for their presentation, as well as Mr. Riley's statement.
You can proceed.
Can you guys hear me over there? All right, beautiful. Good morning, everyone. I want to begin by thanking Board Member Terrones for her presentation this morning. She's addressed nearly every point that I'd like for the board members to hear. Before I respond to address any omissions or corrections or additions, I'd like to acknowledge everybody who is here in support of Mr. Riley. So, will everyone in the room here who is here on behalf of Mr. Riley, please stand up? And I'm not sure if there's a way. Mr. Riley, can you see everybody who is here to support you?
No.
I hope he can.
No.
I also want to call the board's attention to the fact that there are even more of Mr. Riley's supporters viewing the live feed, which is currently on the internet. There are some more family members, some of his recently released peers who were released through the youthful parole process are also viewing. Members of some of the reentry organizations who have pledged their support to Mr. Riley over the course of building his reentry plan are watching online as well and just could not make it to Springfield today for this hearing. And I want to say that the people in the audience on Mr. Riley's behalf today, whether in person or electronically, they make up only a fraction of the loving community that will be supporting Mr. Riley once he's released. He'll have the support of his father, his mother, his 3 siblings, countless aunts, uncles, and cousins, many of whom are here today. But he'll also have the support of countless reentry services. He'll have the support of caseworkers and counselors, and many of those people, as Board Member Terrones has mentioned, he's already begun to build strong relationships with. And because of where he's currently incarcerated at Robinson Correctional Facility, we've actually been able to connect them over Zoom for lengthy conversations. And so it's not just your average half-hour phone call or something of that nature, but these are substantive conversations that he's been having. But this is just one of the many strengths of Mr. Riley's application for parole. Over the time that I've gotten to know Mr. Riley, the thing that has stood out the most to me is how genuinely introspective he is. Today, as an almost 40-year-old man, he has profoundly clear insights into his behavior as a youth. He understands and he actually feels how his behavior affected Mr. Murphy, Mr. Murphy's loved ones, and also the broader community that they both grew up in. He's been honest with himself about what he needs to do with that information too, and he understands what he must do to improve himself, and he has undertaken those efforts. What's important about this quality that Mr. Riley possesses, this genuine introspection, is it means that he's especially well equipped to do the really hard work that rehabilitation requires. And he has done that work. Over the course of his incarceration, he didn't simply enroll in typical IDOC courses. He showed up consistently and intentionally, month after month, for years on end, to individual counseling sessions. And in those counseling sessions, he's earnestly processed his past, his actions, his plans for the future. These this careful processing, it's become a part of his life. It's a part of who he is, and it's a part of who he will be continuing into the future. Now, just one of the things that he's used this introspection to do is he's directly identified the factor that I believe contributed the most to the incident for which he's currently incarcerated. And he's really focused a lot of his rehabilitative efforts specifically on addressing that factor. The specific factor I'm talking about here today is the backdrop of intense violence that he was constantly exposed to throughout his childhood. He recalls hearing gunshots, he recalls acts of violence suddenly erupting, seemingly out of the blue. And I'm not going to go into that in detail, it's documented in the report, but I want to highlight for you the fact that Dr. Quintana's report offers a litany of what she calls quote unquote horrific events that Mr. Riley personally witnessed or was a subject of, one after the other, an unrelenting chronology of the violence that he experienced between the ages of 6 and 17. Well before 2004, Mr. Riley was on high alert. He had no idea that this degree of unrelenting violence was, in his words, quote unquote, not normal. Now, all of this came to a head when Mr. Riley was just 17 years old. During his junior year of high school, that violence intensified even further, and it focused its wrath against the block where most of his family lived. During that year, Mr. Riley, already hyper aware of the potential for violence all around him, personally witnessed friends and family members fall victim to violence. Then, on November 20th, 2004, when he was still a teenager, Mr. Riley did the worst thing he's ever done. In just a moment, he became a part of the same backdrop of violence that he had feared for so long. That night, he found himself already primed for the possibility of violence in a car on a dark street. There, he was startled by another man approaching his car, a man whose nickname was M. Murder, who had told people that he was after Mr. Riley, who Mr. Riley had personally seen with a gun on multiple occasions. Mr. Riley was sure his life was at risk, and he did the only thing that occurred to him at that time, with the resources he had in the place where he was. He ducked in his car seat, he pulled out a gun, and he shot that gun blindly 3 times behind him. And the trial court records document this gesture really well, but it's directly behind his back. And then he drove away. When Mr. Riley learned that those gunshots had killed Mr. Murphy, he was immediately horrified. He was horrified that he'd hurt another person, not to mention that he'd taken a life. He was horrified that he'd let his family down, and he was horrified that he'd contributed to the already unbearable violence of his neighborhood. Mr. Riley has been working to atone for the harm he caused ever since, and he'll continue to do so for the rest of his life. Now, Dr. Quintana is here to talk with you about Mr. Riley's transformation since that moment. With your permission, I'd like to allow her the opportunity to introduce herself and provide some additional insights for the board's consideration.
Can everybody hear me? I hope I'm clear. Okay, I'll go ahead and proceed. My name is Elena Quintana. I am a doctor of psychology, of clinical and community psychology. I work as the executive director of the Institute on Public Safety and Social Justice at Adler University. I appreciate everyone allowing me to join via Zoom, and I would be there if I did not have a flight in a few hours. I want you to know a little bit more about me in that I have worked with both law enforcement as well as the Department of Corrections to work with formerly and currently incarcerated people for decades to create programs that successfully help people who have committed serious crimes to successfully re-enter society. And I take the assessment of such individuals quite seriously, as my main objective is always ensuring public safety. Now, I was asked to conduct a full psychological evaluation for Mr. Anthony Riley to assess his psychological functioning and well-being, as well as his overall projected ability to safely reintegrate into community after 21 years of incarceration. Regarding his social history, it's true that I have written in the report a litany of violent situations, and I think that that is really a symbol of a specific moment in time and place where Anthony Riley was brought up. In the years that Anthony Riley was growing up, the murder rate in the United States was very elevated. It was 9 per 100,000 residents in the 1990s. Now, this might not seem like high, but that is very high compared to most countries that are less than 1, but many industrialized nations. So 9 per 100,000 is very elevated. But in his neighborhood, the rate of killing was 10 times the national average. So from a very young age, Anthony Riley witnessed grisly scenes of death, witnessed the murder of his young friends, and brutal beatings that maimed their targets. He experienced several attempts on his life and felt extremely on edge consistently. As a child, Mr. Riley never felt safe, and with good reason. At the time of the murder, which landed Mr. Riley in prison, he was attempting to verbally resolve an altercation with 2 men when Marcus Murphy approached in the darkness. Now, the appearance of Marcus Murphy was shocking to Mr. Riley, and so he stated his reaction to shoot him was based on a feeling that his life was being threatened. Now, whether or not this is true, it's plausible to feel threatened in this situation, given his overall hypervigilant state and in the context of his life at the time. Murder is the most serious crime, and it's important to see how this act relates to later behavior. So that's why this evaluation is so important. Now, over the course of his imprisonment, Mr. Riley has been in maximum security prisons such as Pontiac, Stateville, Menard, and having very deep experience within maximum security prisons, I can tell you, people get a lot of tickets. It is usual to receive at least 1 ticket annually, and in the entire length of Mr. Riley's incarceration, he has received only 6 in 21 years. Mr. Riley has used his time in prison to consider what led up to the murder of Mr. Murphy and how violence was normalized in his childhood, and how now, as an adult, he can deal with the aftermath of experiencing so much trauma. In prison, Mr. Riley made the exceptional choice to seek out mental health professionals to better understand and manage his symptoms of depression, anxiety, and post-traumatic stress. I say it's exceptional because many people do not trust the mental health professionals with an IDOC, and in his particular case, he would have to kind of break through his own reserved nature and hypervigilance to be able to trust the process, which is what he has done wholeheartedly. Mr. Riley has attended many therapeutic sessions regularly. He began medication management to begin to sleep and think more clearly and actively engage in healing. When Mr. Riley was finally moved to a medium security facility, he began voraciously engaging in all the programming that he possibly could. I thought it was a little bit humorous that he's not a parent, but he engaged in a dad's program because it was available to him and it couldn't hurt. He has continued this and now has been moved to a minimum security facility. I will talk about that in a moment. In terms of brain development, which is very important, when a when a young man is exposed to high rates of threat throughout childhood, it slows the development of the part of the brain that inhibits impulsivity and aids in good judgment. This part of the brain, which is called the prefrontal cortex, does not fully develop until the mid to late 20s, which is 10 years beyond the time that the killing took place, Mr. Murphy. And as like most children and teens that have taken a life, they become adults who are able to fully develop moral reasoning and good judgment. This, according to science, Mr. Riley is no more likely to harm another human being than the average person, particularly after living in prison, facing the full weight of consequences of the life that he took over 20 years ago. Over time, Mr. Riley has shown himself to be consistently nonviolent within the prison setting. He has reached out for help to grow internally and to invest in developing a sound mind with clear judgment, and indeed he has been known as a peacemaker within the prison settings. I conducted intelligence and personality assessments in order to understand if Mr. Riley has any underlying conditions that would cause concerns moving forward, particularly in the free world. Mr. Riley presented as a well-adjusted, intelligent man without apparent pathological symptomology. His assessment was conducted in a setting that was less than ideal. He suffers from loss of hearing, and we were not able to sit in the same room. Instead, I was asked to sit in a separate room behind a thick wall of glass. This was extremely frustrating to me, but I will tell you that in this moment, Mr. Riley took the situation in stride, and he dealt with a very frustrating situation with impeccable calm and grace. And I felt like that was truly indicative of his personal nature. What did the tests reveal? Well, his intelligence tests placed him in the average range of global intelligence, showing that both verbal and nonverbal skills measured in the average range, and his applied intelligence is above average, meaning he does a lot with what he has. He is able to function well in society, including in terms of his executive functioning, even though he has very high childhood adversity. Because of his high childhood adversity, he scored moderately high on the post-traumatic stress disorder checklist, and this is because he ruminates on past events and avoids doing things that remind him of bad memories. What were not present, the symptomology that was not present for PTSD, are any dangerous symptoms such as being violent towards self or others or experiencing delusions. Post-traumatic stress was not paired with any traumatic brain injury, and thus his symptoms are nonviolent and well managed. His moral development is well developed with strong conscience, abundance of remorse, and a yearning to care for others, which is an important sign of maturity and of readiness to re-enter society. His executive functioning, I talked about it as being strong, that's goal-directed behavior, and it ranged from above average to excellent, and especially strong were his skills regarding response inhibition and emotional control. I was able to witness the emotional control when we were met with that frustrating situation, but I do think that both of these things are very important, especially considering the assessment of readiness to re-enter society. His capacity for resilience is strong. He did show mild to moderate signs of depression due to regret for the harm that he has caused, and his anxiety symptoms are mild and well managed. Regarding his personality assessment, which would tell us if Mr. Riley has any ongoing or underlying personality issues. And he answered some things with unusual patterns. And this is something that comes up, and sometimes it's a sign if somebody's trying to present themselves as better than they are. This was not the case for Mr. Riley. His unusual patterns were based on things that maybe didn't stick together sensibly for some people, but they did for him, such as, if I hate the cold, but I love winter. Well, why do you love the winter? Well, because winter's more peaceful than summer. Well, that would make sense given his background. So I just wanted to put that out there, that there was nothing that I was concerned about. There were a couple scales that note hypervigilance that were moderately elevated, meaning he is watchful for potential harm around him. There were other scales that suggest a person who is reserved and controlled in his emotional expression. Other clinical scales that measure more dangerous things such as heightened anxiety, depression, mania, borderline features, or antisocial features showed no signs of acute mood disturbance, inappropriate thought or behavior. There were no serious or concerning signs of ongoing psychological psychopathology, and lots of signs of positive adjustment based on past mental health support.
Excuse me, doctor.
Yes.
You submitted all this in your report, did you not?
I submitted much of it in my report, but because it was not spoken to, I was expanding on it. Would you like me to speed up and just hit some highlights?
Yes.
Board Member Tupi, I do think she has a couple of additions that she wanted to contribute, and I do believe she's near the end.
Yes, sorry. So I wanted to say I reviewed many of his mental health notes from prison. They were numerous. And in these cases where there are numerous case notes, it's important to review them because usually there's some sort of underlying concerning issue. But instead, they did not reveal any problematic psychopathology rather than a man coping with his difficult past. So I want to go to risk need responsivity, which talks about the risks that create problems in coming out, his responsivity to potential interventions designed to address that risk. All of these things were shown to be low in his case. He does not have mental health issues that create problematic behavior. He doesn't have substance abuse problems, and he is not given to violence at this point in time. So his risk need responsivity assessment is shown to be low. This is underscored by IDOC, which did their own test, which was also shown to be low with his ORAS that was conducted in 2023. Additionally, without requesting a move, IDOC transferred Mr. Riley to a minimum security facility, which is unusual move, suggesting IDOC experiences him to be rehabilitated. In terms of re-entry, given his mental health adjustments, as well as his robust housing, employment, mental health, social support plans, and his ability to positively contribute to society, I think that he has high emotional intelligence and excellent executive functioning. All of these things suggest he is ready for release. Given his mindset and the length of his imprisonment, his moral development, and the very real opportunities that he has now, I believe he is ready for release, and furthermore, that he would contribute positively to his family and his community. After 21 years of incarceration, more prison would not serve public safety and would actually take away from Mr. Riley's ability to establish himself as a positive, responsible, tax-paying citizen that he is ready to become, rather than a human moldering behind bars, wasting taxpayer dollars. Mr. Riley is not a threat to public safety, and he is poised to be a contributor to public safety. Without reservation, I assess him to be ready for reentry.
And thank you, Dr. Quintana. I just wanted to note briefly for this board, Dr. Quintana mentioned the robust release plan that Mr. Riley has worked so hard to compile. I know you guys have all received a copy of the second supplement that we filed in this matter. There's been a significant number of updates since we originally filed the supplement. I want to note some just two general aspects of the additions to his reentry plan. And the first aspect I want to note is that the plan is not speculative or aspirational. It's in place here and now. This means that the foundational services that are a critical part of his plan, and of everybody's plan for that matter, but they've been finalized and they'll be available now. So we have St. Leonard's, which has a place for him, both in their programming and in housing. And I wanted to add to Board Member Tarona's presentation that Adler University has also confirmed that they'll have therapy and processing groups available for Mr. Riley. They partner with St. Leonard's, and so they provide on-site access to counseling. Also, Precious Blood Ministry of Reconciliation has reentry programming that's immediately available, and so as I'm sure this board is aware, there's a very high demand for many of these programs, in part because of how effective they've proven to be. And I think each of the letters that we submitted discussed their effectiveness, so I'm not going to go into that. But as a result, it's especially impressive that Mr. Riley has managed to finalize confirmation from each of them simultaneously all at once. So these services are available now. The second point that I want to make to the board about Mr. Riley's reentry plan is that Mr. Riley recognizes the importance of ensuring that his reentry transition is as seamless as possible. So to that end, he's already worked to form relationships that will extend into his reentry. He's personally met with David Harris, who's the intake housing manager for St. Leonard's. And like I said, these conversations that he's having are hours-long conversations over Zoom. They're not mere phone calls. They're not mere intake checklists. And he's also met with Eric Anderson, the pre-release case manager at PBMR. And they've had a really substantive conversation connecting about their previous experiences, shared experiences as incarcerated men. And then I want to note that family has always been important to Mr. Riley, and it will continue to be important upon his release. And an interesting aspect of his release plan is that he's intentionally worked to involve his family members in his release plan. So we've worked specifically with Adler University to confirm that they will offer opportunities for his family to be involved in counseling sessions, in group reentry processing sessions, or other services that they offer. And St. Leonard's has also confirmed, when we were talking to David Harris, he confirmed that the case managers at St. Leonard's have the capacity to work closely with family and will do so in Mr. Riley's case. And finally, Precious Blood has also confirmed that they'll work closely with family. That's contained in the letter that we submitted, so I don't want to go too much into that. But I do want to note that Ms. Angela Riley, who is Anthony Riley's sister, has actually met with representatives from PBMR to learn about the ways that she can best support Mr. Riley when he's out, just to make sure that she's checking all the boxes. And she's talked to them about the programming that's available to Mr. Riley, but also the programming that's available for family members, just to make sure that they can support him as substantively as possible upon his release. And just finally, there's one part of his release plan that's especially representative of his introspection, his remorse for his behavior, and his recognition that he caused harm, and also of his efforts to atone for the harm that he's caused. He's adamant about the fact that upon his release, he wants to work with youth to offer them wisdom and guidance, and he's especially eager to work with them in the community violence prevention context, since this is the context that influenced him so much in his own childhood. And like the other pieces in his release plan, this piece too is already in place, and it's just waiting for Mr. Riley's release. He's already been mentoring other men in prison, but what's exciting here is that Michael Harrell of PBMR, the Director of Reentry Services there, has offered him volunteer and training opportunities in violence prevention. Eric Anderson, with whom he's already formed this relationship, has also offered to work with Mr. Riley as he learns about this new field, and to share his own experiences as he became familiar with the field as well. So they'll be partnered. And so the weight of Mr. Riley's case and the recognition that he caused irreparable harm, they drive him to be better. It's given him purpose, and that purpose is to repair harm and to work toward better outcomes in the community. So with the board's permission, Mr. Riley has prepared a statement to share with you, explaining the way that all of this has influenced his personal transformation. And so I would like to turn it over to Mr. Riley to speak, if that's okay with the board.
I think the board would like to hear from Mr. Riley.
Thank you.
Wait, ask him if he's ready.
You can hear me?
Yes.
All right, good morning. First, I'd like to thank the board. I appreciate you dearly for this opportunity. It hurt me deeply knowing I've taken Mr. Murphy's life. It's something I have to live with for the rest of my life. Something
Excuse me,
I can't
sir.
take back.
Sir, I need you to speak up just a little bit louder, please.
It's a little difficult to hear you, Mr. Riley, on this end of things. I'm wondering if you can lean closer to the microphone.
Right. All right.
Try.
All right. Good morning. Y'all can hear?
Is that better?
That's much better. Thank you.
All right. All right. First, I'd like to thank the board. I appreciate you dearly for this opportunity. It hurts me deeply knowing I've taken Mr. Murphy's life. It's something I have to live with for the rest of my life. Something I can't take back, something I'll always regret. The guilt I felt knowing I robbed him of all life possibilities, knowing it was the decision I made in an instant that changed the lives of many for the worse, has been a struggle throughout for me. I found myself trying to justify my actions in an attempt to free myself of the guilt that weighed heavy on my heart. Going through the process of growing, learning, and developing with therapy, I realized the negative impact my actions had on my community as a whole. Through therapy, I learned the reasoning behind my past behaviors. Unbeknownst to me, I was struggling with PTSD, and I didn't understand it or how to deal with it in a healthy way. Not to be mistaken as an excuse, it was my choice to pull the trigger that took Mr. Murphy's life. Since being incarcerated, I've taken steps to address these issues. I've worked hard to understand the root cause of my actions. Through this process, I've learned better ways to manage my emotions, make thoughtful decisions, and take responsibility for my actions. I now understand the importance of maintaining my mental health and have planned to continue treatment and support if granted parole. I am committed to continuing this work because I want to live a stable, positive life and contribute to my community. I understand the seriousness of my past action and I take full responsibility for them. My goal is to never return to that place emotionally or mentally ever again. And I've equipped myself with the tools and support I need to stay on the right path and to contribute positively to my community. This next chapter of my life, I plan to spend it making up for the harm I caused others by doing good. And learning to forgive myself, I found joy and a new sense of purpose in helping others. I have many great opportunities in place, and I plan to explore all options, not allowing myself to be limited to one thing. I'm especially proud to be a part of Precious Blood Ministries, and I look forward to sharing positivity throughout the community. Therapy has been my guiding light. It's been a place of information and support and compassion when I needed it the most. Thank you to IDOC for seeing I was sincere about bettering myself by offering me mental health resources. I can honestly say I wouldn't be the person I am today without it. To the family of Mr. Murphy, I want to acknowledge the harm I caused by apologizing to you. My deepest apology goes out to you and your family for the endless heartache I've caused. I'm reminded of my reckless act every day. I understand the pain and suffering I imposed, and for that I am truly sorry. It was never my intention to take your son's life. It was a situation where I reacted poorly, and if I could take it back, I would 1,000,000 times over. Therapy has taught me to recognize the harm I caused and accept that you may never forgive me. I know it's nothing I can do or say to change that. I can only learn from the situation and give back by helping prevent violence that my action contributed to and be a positive light for someone, be a positive light for others, keeping them from making the same mistakes I did. Again, I am so sorry for everything. May God bless your soul, and I pray that you someday find peace. To the parole board, a heartfelt gratitude for making this all possible. If granted parole, I am committed to following all conditions, continuing my personal growth, and living responsibly. I am hoping for a chance to show that I am not the person I was 20 years ago. I have the full support of my family and a solid foundation to begin again. I ask for the chance to demonstrate my growth, my remorse, and my commitment throughout my actions moving forward. Thank you.
What happened on the night of November 20th, 2004 was absolutely a tragedy, and it affected the entire community. Mr. Riley does not shy away from the role that he played in that tragedy or the harm that his behavior caused. He's been reflecting on that harm and how he can possibly atone for it for the past 2 decades. Over the course of those past 2 decades, he's demonstrated deep remorse for his actions, he's accepted responsibility for them, and he's responded by working hard to change both himself and his circumstances. He's now a 38-year-old man. He served more time in prison for this offense than he was alive before his arrest. He wants the opportunity to give back. He wants to be a son to his father, a brother to his siblings, an uncle to his nieces and nephews, and he wants to serve as a mentor and protect other young men from making the same mistakes. For all of these reasons, I urge this board to grant Mr. Riley's application and release him onto parole. Thank you.
Thank you. Thank you. We're going to hear from State.
Yes, good morning again. First, I'd like to acknowledge that there are 2 victim protesters on this case. We didn't go into a closed session for you guys to discuss that, but there are 2 family members of Marcus Murphy's who vehemently oppose granting of parole in this case.
That was documented on your letter. That's why.
Okay, thank you. It is our position that granting Mr. Riley parole at this time would deprecate the seriousness of the offense and promote disrespect for the law. Mr. Riley was resentenced very recently in April of 2023 in consideration of his age at the time that he committed this murder and his institutional adjustment, his rehabilitative efforts, his expressions of remorse, and after hearing all of that testimony, the circuit court concluded that 25 years was the appropriate sentence in this case. That sentence gives Mr. Riley a second chance. Marcus Murphy does not have one. Additionally, Mr. Riley's IDOC disciplinary history is very concerning and indicates that he will not conform to the reasonable conditions of parole. He's received multiple tickets that involve violence, including dangerous disturbances, specifically 9 shots fired, gang or unauthorized organization activity, specifically 4 corner hustlers, fighting, disobeying a direct order essential to safety, and abuse of privileges. He received tickets again in 2019, in 2020, in 2021, and in that's it. And again, there are 2 victim protesters in this case, and the State Attorney's Office does oppose the granting of parole in this case for those reasons. Thank you.
Thank you.
If I may respond briefly,
Yes.
Would that be appropriate?
Yep.
Thank you. I want to say that over the course of the past 2 years that we've been having these hearings, I think 25 hearings in all by my count, maybe 26 after this morning's earlier hearing. We've talked a lot about what the youthful parole statute means and what it asks of us. We've talked about the fact that the inquiry is different than conventional indeterminate parole inquiries. We've talked about the fact that this board plays a really important role in ensuring that the youth sentencing statute is constitutional, and that that role is distinct from the role that sentencing or resentencing courts play. And we've also talked about the fact that the members of this board are uniquely well equipped to play that role. This board has the tools, the experience, and the perspective to examine the degree of a candidate's rehabilitation as well as their readiness for release. And yet the state's attorney's response, both in the letter form and here today, just seems to disregard each of these discussions that we've had over the course of the past 2 years. I want to mention briefly that the letter that was submitted focuses very heavily on the facts that were elicited at trial. And of course, these facts can't be ignored. And indeed, Mr. Riley recognizes in no way intends to undermine the gravity of the acts he committed. But the letter and also the state's attorney's comments this morning make no reference to Mr. Riley's rehabilitated efforts or his youth. And in fact, it makes no reference to this portion of the statute at all. And I think that's especially important just in light of what you've heard today from Dr. Quintana and what you've read today in the supplements we filed. The second point I want to make is that it completely disregards the role that this board plays in the criminal legal system, and it's an important role. And as this board knows, the sentencing judge and the board are tasked with completely different considerations, and the board is the best equipped body to determine whether someone should be released. Most judges, for instance, have never been inside a prison. They don't know how hard it is to survive in Menard, especially as a teenager. They don't know about the lack of programming, violence, lockdowns. They don't have the same understanding of the hard work that it requires to thrive and remain committed to improving oneself in those conditions. They don't spend time interviewing Mr. Riley and his support system, just like board member Toronas did just last month. But also, and we heard testimony about this at the hearings back in January, sentencing judges anticipate now that the petitioner will be eligible for parole. And at parole hearings, the considerations that you all will be examining will be different than the considerations that are in front of the sentencing court. And I just want to make the point that, finally, contrary to what the state's attorney's letter indicates or suggests, this board has significantly more information before it today than the resentencing court ever had in the first place. It's my understanding that at the resentencing hearing, there were 2 witnesses presented for the defense. They were Angela and Natasha Riley. There was no mitigation done, and the court didn't have the benefit of an expert to help it understand Mr. Riley's rehabilitative efforts and suitability for release, not to mention an expert like Dr. Quintana, who specializes exactly in these subjects. It also didn't have the benefit of the robust release plan that Mr. Riley has since assembled, among several other items that I won't go into because I know we're running up against time. I just want to say there's every indication that Mr. Riley will conform to the conditions of parole. He has a robust release plan, as we mentioned, but also it's significant to note that multiple psychological tests and multiple reentry specialists notes that he presents the lowest possible risk for recidivism. A grant of parole will also not deprecate the seriousness of the offense or promote disrespect for the law. When viewed alongside the mitigating factors of adolescence, Mr. Riley's sincere remorse for his actions and his really profound rehabilitative efforts, 20 years is absolutely an appropriate and in no way lenient sentence. And finally, his release will not have an adverse effect on institutional discipline. To the contrary, it will serve as an inspiration to the many men whose lives Mr. Riley has touched, both inside and outside of prison. Those who have witnessed his transformation, those he's mentored, those he'll mentor in the future, and those who look up to him. Put simply, he's an exceptionally qualified candidate for release. He exemplifies the person that the youthful parole laws, many drafters, advocates, and stakeholders envisioned in benefiting from this sort of consideration. And for all of these reasons, I urge you to grant Mr. Riley's application for release and release him onto parole. Thank you.
Thank you. Questions?
I have a question for Ms. Quam. Do you know what position each of the parties took at the resentencing regarding what the sentence should be?
No, I'm sorry, I do not.
Ms. Lindner, do you know?
I imagine, I don't know specifically that there has been no transcript generated in this matter. I did have the opportunity to speak with the attorneys who represented him. They're the UIC's clinic, and I imagine that they were asking for immediate release.
Thank you. We do have to go into closed session now, so at the appropriate time, doesn't have to be now. I'd like to do that.
You can motion to do that.
All right. I move we go into closed session to address matters the statute provides for us to discuss there.
Mr. Grubbs seconds.
Thank you,
Motion's
everyone.
been made and seconded by Mr. Grubbs to go into executive session. Those in favor respond by voting aye. Aye.
Aye.
Go ahead, we can go through this.
All right, everybody's present, so we can finish up with the presentation. Last I saw, there were 3 questions. 3 people had questions. Does anybody still have any questions for either Ms. Toronis or Ms. Linder at this point?
I do have a couple of questions.
All right, Mr. Bolin.
Thank you. Okay. Historically, there have been some arguments towards self-defense, specifically in some post-convictions. I kind of hear at least maybe a potential that we're walking away from the self-defense argument. Where do you stand today in regards to that? Mr. Riley, if I could.
At the time, I felt it was me being on high alert, it was a lot going on. I felt it was a shoot or be shot moment. I now know I had other options, and that me being on high alert and afraid don't amount to being self-defense.
Okay. If I may ask, I believe in one of your versions of events, you mentioned that Mr. Murphy had exited his home where he was on house arrest, suggesting that that's where your car was stopped. Why were you at Mr. Murphy's house in the first place?
We was a block away from his house. I was on my way to my grandma's house.
Okay. As Ms. Quintana has mentioned today, certainly been argued in prior hearings and so forth, there's a recognition that maturity tends to complete itself around the mid-20s. The reason I bring that up is that in this particular case, I do have some concerns with the noted tickets. The reason being, what we would like to see typically is some kind of decrease or fall off in that kind of behavior about that age or sooner. But in this particular case, there were almost no tickets from the time you came into custody in your teens through about age 30. And then all of these tickets from 2017 to 21 are from age 30 to 34. And there seems to be, in your accounting of these tickets, a relative claiming of innocence in all of these major tickets. I'd like to hear from you. Maybe let me ask first, where is that where you stand today as far as those tickets are concerned?
Not all of them.
Do you want to go through?
Yeah.
I would like to begin just by, since Mr. Bolin has brought up the 2017 incident, I just want to remind the board of the fact that we've seen this 2017 incident, by my count, 3 times already. This incident, as you may recall, is an incident that happened at Menard, obviously in 2017, where a fight expanded into the entire yard, and everybody that was at yard on that day was issued a citation. And we've seen this, I think, at least 3 times. I've heard testimony from defense witnesses about that specific incident. And so to the extent that Mr. Boland is concerned about this particular ticket, I do want to note that this is a ticket that we have tons of evidence about the fact that this was an incident where just everybody who was on the yard on that day was cited.
Okay, fair enough. Would you like to confirm your stance on the other tickets in 2019, 2020, 2021?
Board Member Boland, are you asking Mr. O'Reilly for his general perspective on these tickets, or are you asking him to describe each one?
Well, for instance, what's been presented to us is for 2019, claimed that the phone wasn't his. 2020 claimed that he was taking the blame for somebody else's contraband. 2021 states that it was actually an incident involving other inmates play fighting, and that they just refused to leave the yard.
Yes.
So is that record that's before us where you stand today?
I think, okay, thank you.
Go ahead. Say what you'd like to explain.
All right, I'd like to explain the 2019 ticket. Another individual in another part of the facility was caught with a cell phone. They say 2 of my numbers on my approved pen list was also in the cell phone. That's why I received the ticket. But we was on opposite sides of the facility. There's no way for me to use a cell phone.
And I think one thing that Mr. Riley has told me about this incident is the fact that the individual who was with this cell phone, who was caught, was in a completely different housing unit than the housing unit that Mr. Riley was in. So there wouldn't have been an opportunity for them to interact with each other at all. What's being alleged in this citation is merely that numbers that were on Mr. Riley's approved list were present in this cell phone. So nobody's alleging that he touched it, that it was in his possession, or anything of that nature. That's why he was issued the citation. And what's interesting about the layout of where the person with the cell phone was found was that these two men couldn't have had contact with each other, not even at yard. They were in 2 separate housing units. So I understand, Mr. Boland, your concern that there are a lot of extenuating circumstances cited here. However, I think that is because there actually were quite a few extenuating circumstances at issue here. And I wanted to note a new thing that I discovered about this 2020 ticket as well. I just discovered this yesterday, but the prison was under a boil water advisory. This is back when Pontiac was asking people to boil their water. This is when, you may remember, when Legionnaire's disease broke out in Pontiac. And so the prison was asking people to boil their water, but they weren't offering means by which they could boil their water. So Mr. Riley is absolutely accepting responsibility for this 2020 incident. The tool that is at issue here is the tool that he was using to boil water in the middle of a Legionnaire's outbreak.
Okay. Based on this, I guess let me ask one more question. Have there ever been an incident, a time when you were not forthright with your ticket history, be it at resentencing, counseling, therapy, what have you? Is there any incidents where you weren't forthcoming about your ticket history?
No.
Are you asking about a specific incident, Mr. Boland?
I'm asking if he's ever withheld information about his ticket history from anybody that he would have been having any kind of interview with.
And do you have a specific incident in mind that you're concerned about, may I ask?
There is some record, but that's why I'm asking this individual.
What is the record that you're concerned about?
I would like for him to answer the question, is what I would like. Has there ever been any incident where you were dishonest about your ticket history with anybody?
Not to my knowledge.
Okay, fair enough. That's all.
Any other questions, Mr. Boland?
No.
Ms. Globoker, did I see you have a question? Go ahead.
Yeah, a couple of brief questions and one a little bit more extended. Has anybody been able to independently verify for the 2021 ticket that there were multiple individuals that had received tickets for that incident, or any of the facts?
We weren't able to get any additional records on this fact, no, but I do understand that there were multiple individuals cited.
Okay.
I don't, but I have a follow-up question with hers to counsel. Who did you speak with at the facility to confirm the information you just shared?
It's just my understanding of the events that occurred.
Okay.
My conversations with Mr. Riley.
Okay. I know there was an earlier ticket, I believe it was the 2017 ticket, but it did make reference to a specific affiliation. Did you want to speak in terms of whether there's been any interaction? I mean, obviously there's been interaction in an institutional environment, but whether there's been any involvement in terms of street organizations or what that, what your path has looked like in relation to that?
I never been affiliated with no gangs. That was the only ticket I got. 40 people on the yard received the same ticket. Like in the street, I wasn't a part of a gang or in prison. It was something I wasn't into. I watched them kill each other. Like, why would I be a part of that? Like,
I respect that. Thank you. Is Dr. Quintana still with us?
I hope so.
She is.
She is? Okay, she might just not be visible. I just wanted to address a point that she had made. She had cited high homicide rates from the early 1990s as context for this offense. National homicide rates peaked in 1991 and declined significantly up until the time of this offense. At the time that this offense occurred in the early 2000s, crime rates were not dissimilar to what they are now. I would also challenge the characterization of bifurcating crime rates at that time with now. There were 448 murders in Chicago the year of this crime, per Chicago police statistics, and 573 murders this last year. As far as how it relates to this offense, I know that PTSD, trauma, being on high alert are common and understandable for young men that are growing up around high rates of violence and some of the exposure that you may have encountered. Clearly those things are still going on. Unfortunately, it's still a cold, cruel world in a lot of spaces, and the sound of gunshots is not uncommon. Have you, Mr. Riley, had the opportunity to speak to individuals just as far as navigating that current environment and dealing with some of the stresses and dangers that continue to exist in many of these spaces?
through therapy, we talked about it, went over it, but by me going to a new environment, different setting, I feel like I'm more than prepared.
And I would like to add that in putting together Mr. Riley's reentry plan, he was specific about wanting St. Leonard's because St. Leonard's, A, offers an abundance of services, but also because it's in a different part of the city than the area where he grew up. And he just wants to make sure that he's doing this right from the start. And he specifically told me just wanted to start somewhere new. So.
Yeah, I mean, I think the entire board is familiar with the supportive environment at St. Leonard's, and I respect that in terms of a plan. I know you had mentioned working with youth and anti-violence as well, and there are certainly youth today that are navigating every bit of the fear and trauma that you would have been surrounded by as a youth. And obviously a big reason a lot of individuals carry weapons is for self-defense, that they're fearful for their own safety. If you were sitting across from that 16, 17, 18-year-old kid that's dealing with the same situation saying, man, you don't know what it's like out here, there's a lot going on, what do you tell them?
Teacher, it's ultimately all up to them, the choice they make. Like, you can remove yourself from the situation. And I also try to work with the parents, get the parents involved. Like, get them to do something, give them an outlet, basically. Something else to do besides that.
Thank you, Mr. Riley. I do just want to mention, and this is more in terms of the attorneys or expert witnesses that come before us, please ensure that the information you bring is defensible. The smoke and mirrors approaches do risk detracting from what are the genuine merits of your client. And so, Mr. Riley, that is not a knock on you. I just wanted to clarify for the record in terms of how crime rates relate to this offense and, unfortunately, the landscape that's still out here. But Mr. Riley, I certainly appreciate your responses and respect the sincerity in wanting to contribute to the solutions in the present day. It's certainly needed. So thank you.
Thank you.
Well.
Any questions? Any other questions? I just have one. Well, I just have one. Actually, two. You said you looked at the record on the sentencing and that he had 2 witnesses for that. Is that correct?
No, the record was unavailable. The transcript hasn't been generated. So I spoke with the attorney who represented Mr. Riley to get some sense for what had happened, because I know that the board is always interested in that sort of thing.
Okay. Do you know what he recommended for the sentence for the court?
That's not a question that I asked, because I assumed over the course of our conversations that he had been asking for immediate release, as many attorneys do.
Okay. Then the other thing is that you stated that a lot of the evidence that you presented at this hearing was not presented but to the court.
Yes.
But it could have been if the attorney had gathered the evidence and hired the doctor and talked to Precious Blood and St. Leonard's. They could have got all that information available if they had done the work that you did on this case. Is that correct?
You know, I can't speak to what that attorney had the capacity to do. It was an attorney who was working for a legal clinic, but I can't speak to what their constraints were, what was permissible. I can say that Mr. Riley has done a ton of work even since his most recent resentencing, which I think is really important to note. He's consistently engaged in therapy since he moved to Western, which is not where he is now, but even when he was moved to Western, he was finally able to get a job, so he was working, he was engaging in programming. At the time he had his resentencing hearing, he really hadn't had access to a lot of the programs that are in front of you all as programs that he's completed today.
Okay. Well, I think the board has toured St. Leonard's house, and we're all aware of Precious Blood and the good work that they've done. That's the only question I have.
Thank
Any
you
other
so much.
questions, Ms. Taronis? Do you have anything further?
No, I don't. I'm prepared just to make the final closure.
Ms. Globoker, your mic's on.
Yeah, I was just going to commend Mr. Riley as well for leaning into those supports within IDOC. And clearly his strong support system, we could all use a little help from our friends, and whether your day is today or a few years from now, I just wanted to share my respect for the introspection and hard work that you've done.
Thank you.
All right. Seeing no further questions, Ms. Taronis, do you have a motion at this time?
Yes, I just want to tie this all together for all of you. I know that this has been a very robust discussion as it relates to information to best inform our decision today. And Mr. Riley, thank you for sharing all that information and continuing to do what you need to do well, and you have a strong counsel. So you have heard colleagues from the expert witness, Dr. Quintana, and you're familiar with research as it relates to youth offenders and how it impacts decisions, behaviors. The testimony of Mr. Riley working to be more a master of self to demonstrate to the larger community his rehabilitation, his accountability, and gratitude. We also see that the judicial decision of resentencing of 25 years could be considered grace and a second chance. And it was the judge given this responsibility at that time to make that decision, and we are here to continue making decisions as requested by returning citizens and community. Mr. Riley, during the 21 years served, has demonstrated courage as he lives to repay his crime to society and family in our institutions where we send individuals to be accountable. Self-discipline is a value that I see that he has taken, and beyond the courage that he has displayed to support the impact of what his intentions will yield based on this difficult setting. You know, support systems are a real critical component to keep people balanced in our institutions and also dealing with their selective choice of harming others in community and the murder that he committed bringing him into IDOC. But the family has really stayed by his side to give him that balance of mental health, and he has also taken that initiative to continue to inform and impact. You know, Mr. Riley has demonstrated initiative by the evidence in the application packet by taking advantage of programming that he initiated to make available for him, demonstrating perseverance, and attaining and keeping that knowledge to support his decisions in the institution and future. Information is critical to the healing, to the understanding, and the gravity of the pain he caused to the family and victims. So he has demonstrated to the individuals and institution the path of how they can also recover, be accountable, and continue to seek that support through their family and the larger community. You know, Mr. Riley has been consistent in expressing his remorse in many ways. and he will continue his intention of living a life in service as he has indicated in community to all today and in his application packet. Mr. Riley has certainly communicated to us and revealed to himself the individual he can be while in IDOC. And I have to take a moment, as Mr. Riley did, to recognize IDOC and their accompaniment to him to make programming available, as we see typically that is not done for individuals with this extended period of time. So he continues to pursue, legal options for himself, as we see by the pending clemency that he has that is a non-public. He does have a release date of 2029. Mr. Riley demonstrates appreciation for himself, as I indicated earlier, and also for the necessary supports that he is receiving. If Mr. Riley returns to community, he will not deprecate the law. He has done 21 years. The judge that determined the sentence, that was his judgment, and now we can exercise our judgment on this youth parole request. My motion is to grant parole today based on the information heard and received.
Motion's been made to grant. Do we have a second?
I'll second it.
All right. Motion's been seconded by Mr. Heaton. Please call the roll.
Ms. Taronis,
Yes.
Ms. Tyson,
Yes.
Mr. Boland,
No.
Mr. Coates,
No.
Ms. Glohoker,
Yes.
Mr. Grubbs,
No.
Mr. Heaton,
Yes.
Ms. Schaffner,
Yes.
Mr. Tupy,
No.
Thank you.
Mr. Riley, thank you for being here today. And I would ask that your commitment continue and that you return and share your story with us anytime possible.
Thank you, everyone.
Keep a clear head out there, Mr. Riley. I wish you the best. Whoa.
What did you say, Julie? Oh.
Let's take a 5-minute break while we clear the room and get ready for the next hearing. The next hearing is going to be Freddie Martin. Seeing everybody's here, Mr. Grubbs, are you ready to present Freddie Martin? Yep, please call the case.
We have Freddie Martin, presented by Mr. Grubbs.
Do you have any witnesses? No
We got 2 protesters.
Okay. All right. Go ahead.
You ready? On March 21st, 2025, I interviewed Mr. Freddie Martin from the Illinois River Correctional Center in Canton, Illinois. Mr. Martin is 76 years old. He has 3 sisters, 1 brother, though 1 sister is deceased. In his last parole interview, he stated he is married and that his wife is still living somewhere in Virginia, but he's no longer certain of this at present. Together they had a daughter, though the daughter died back in 1973. His last contact with a visitor was in the early 1990s and was with his mother and his sister-in-law, though he did indicate he has spoken with friends and attorneys since then. On the early evening hours of January 15th, 1976, Mr. Martin, then 27 years of age, entered the Harvey, Illinois home of Herbert and Catherine Alferink, who were in their mid to late 70s at the time. Upon gaining entry, Mr. Martin tied and bound both victims and searched the home for valuables. He took jewelry, money, and a television. Next, he stabbed both victims repeatedly in the chest until they were deceased. Before leaving the house, Martin turned on the gas stove. After he had robbed and murdered Mr. and Mrs. Alferink, he went to a nearby bar where he met another man and asked him for a ride to Chicago. The man noticed Martin had blood on his shirt and pants, so he questioned Martin about whether he had been in a fight. Mr. Martin stated to the gentleman that he had killed 2 people at a residence on a nearby street, which caused the man to tell Martin he didn't want to get involved. But Martin armed himself with a knife and threatened the gentleman, causing him to run away. Martin left the bar on foot and was stopped by police shortly afterwards. He was carrying a television. He explained to the officers that his car had broken down. The officers documented the encounter with Martin and released him. Martin then summoned a taxi, which took him to within a half block of his home. When the daughter of the elderly victims arrived at their home the following day, she discovered her murdered parents on the kitchen floor. Her father was lying face down while her mother was on her back with a knife in her chest. Their hands and feet were both bound with rope. When the police turned Mr. Alferink's body over, they discovered a knife embedded in his chest. An autopsy revealed Mrs. Alferink had been stabbed 5 times in the upper chest and had abrasions in her lower and mid-chest and right thigh. The cause of death was by stabbing, as was the death of Mr. Alferink. Police found the bedrooms of the home ransacked. That same day, a vehicle was stolen from a local business. A few hours later, Chicago police officers located the stolen vehicle and found Martin to be the driver. They tried to stop the car, but Martin took off at a high rate of speed, trying to elude the police. Eventually, he abandoned the car, fled on foot, though he was caught. When police caught him, they discovered a revolver and several keys on his person. Martin was charged with theft of the vehicle. Following a bench trial, he was found guilty in 1976, sentenced to 1 to 4 years in prison. After he was taken into custody for the theft of the vehicle. Harvey police received a tip from an informant regarding the murder of the Alfrinks. This resulted in a search warrant at Martin's home, where police recovered the Alfrink's stolen television. They were then directed to Martin's wife's home, where they recovered 2 rings stolen from the Alfrink home. This eventually led police to another person's home, where they also recovered a $1,000 cash bond of the Alfrinks. Martin's wife informed police she got the rings from Mr. Martin and that he had given the other man the $1,000 cash bond. He was also alleged to have a large bundle of money hidden in his sock. Martin was charged with murder, armed robbery, burglary, and the jury found him guilty in all counts in December 1976. The judge sentenced Martin to 150 to 450 years for the murder of Herbert Alfrink, 150 to 450 years for the murder of Catherine Alfrink, 20 to 60 years for armed robbery, and 3 to 9 years for burglary, all to be served concurrently. At Mr. Martin's jury trial, the state introduced information regarding 2 other murders which were being investigated, where Mr. Martin was the prime suspect, though no charges were ever brought forward regarding those incidents. Mr. Martin would only state during his interview that he had had a trial and was found guilty, and he denied his guilt. He also denied a statement attributed to him where he was said to have indicated in his previous parole interview that he didn't care what the board thought about him. He said he never made that statement. He went on to bring up on his own that he was a member of a street gang prior to incarceration. He stated he renounced his gang membership, but there was no documentation of this in his file. And that's really the end of what he wanted or was willing to speak about regarding the offense for which he's convicted. He's been incarcerated 3 times. Following a 1971 parole release, and less than 6 months later, he committed a robbery. In 1975, he had been paroled for less than 4 months when he murdered Mr. and Mrs. Alfrink. His criminal history dates from 1968 to 1976 for robbery, theft, and burglaries. Of significance are crimes against elderly victims. Regarding his institutional adjustment, he has over 75 institutional disciplinary incidents. Most of those were between 1977 and 2016. There was one since 2016 in November 2021. That was for unauthorized property. He's currently A-grade minimum security. He has earned an associate's degree in applied science and has had several certificates in electronics that he's earned from Joliet Junior College. Though he's not participated in programming or employment for the last 6 years, he explained this was due to his advanced age. As far as opposition, the Cook County State's Attorney's Office has submitted a May 2025 letter opposing parole. There are also detailed and impactful opposition letters which have been received currently and throughout the years from family members of the victims regarding the murders, their loss, and the impact that it continues to have on them. This is Mr. Martin's 31st en banc hearing. His last was in May of 2022. Mr. Martin's only parole plan is to temporarily live with his sister before transitioning to a yet-to-be-determined transition center. He would prefer to reside at St. Leonard's Ministry. He recognized he will need assistance with reentry, especially with his mental health needs. He stated once again that he's too old to work and did not know how he would support himself. Mr. Chair, we do have Cook County State's Attorney's Office here, and we also have victim protests to be heard in person today, and we'll need a closed session to hear protests that was heard earlier.
Okay, we're going to hear from the state's attorney's office. The 2 victim protesters are going to testify. I'm going to advise you that this is a public hearing, and once you testify, then your names and information could become public. If you've testified in a closed session, then they won't. But I'm advising you, if you testify here today, it's possible your identities could be FOIA'd. I'm just for future reference. So we want to hear from the Cook County State's Attorney's Office first, and then we will then let them make the decision if they want to testify here today.
Thank you. The Cook County State's Attorney's Office vehemently opposes parole in this case. There is a substantial risk that Mr. Martin will not conform to the reasonable conditions of parole. His history demonstrates a pattern of escalated criminal conduct, leading up to 2 murders for which he was convicted. His prior experience with parole provides an opportunity to evaluate, in concrete terms rather than speculative ones, his ability to conduct himself lawfully, and demonstrates his inability and unwillingness to do so. Mr. Martin's release would deprecate the seriousness of these vile offenses and promote disrespect for the law. Mr. Martin exhibited a frightening pattern of behavior with similar motives and methods for each offense. The brutality of the crimes that Mr. Martin committed cannot be understated. He deliberately preyed on elderly citizens of our community, and he took advantage of their kind nature. We ask that the board considers all prior letters of protesting parole for Mr. Martin, as well as any prior recorded statements that were made by our office, by any victims or victims' families. And we also request that the next parole hearing be continued for an extended set in acknowledgement of the victims' families and them having to testify pretty often and relive this horrible crime. And with that, the State's Attorney's Office opposes parole in this case. Thank you.
Any questions for Mr. Grubbs or the State's Attorney's Office at this point? Seeing none, do the 2 witnesses, are you still wanting to testify, or like I said, it opens your names up at this point? No? Okay. We will go into closed session, and we will hear the protests from that were made in closed session.
We will testify.
They would like to testify. They just misunderstood.
And you understand that opens you up? All right.
Okay.
Huh? Okay. You can go ahead. You need to be sworn in, and then you can testify.
Please stand and raise your right hand. Do you solemnly swear or affirm that the testimony that you will give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you. My name's Joanne L. Frank. My husband is the grandson of Catherine Herbert L. Frank. And so we are
Could you pull the microphone closer, please? Thank you.
So my name's Joanne L. Frank. My husband is the grandson of Herbert and Catherine L. Frank, and we just agree with the state's attorney. This has just been overwhelming for our family and still affects us today. They were innocent victims. Again, their only crime was being nice people and wanting to help somebody, and we feel like we continue to be victimized coming for how many years now? This is his 31st one. Somebody from our family has always been here to protest because, again, the significance of the crime, the hardship it's caused our family, the hurt. This is a man that hasn't learned from parole in the past. I fear for our family and our friends. You know, when he was out on parole after attacking George's family, he was seen in the neighborhood. At this day and age, you could look up my name very easily. You're going to see a nice little picture of my house if you Google it. My car parked in the driveway. I just feel it would put my family at risk. We're getting older. We're vulnerable. I have a son who's expecting a new baby. I don't want to put my son and his family at risk. I don't want to put our neighbors at risk. We're active in our church and our community. It's not fair to them. This is a man that has never shown any remorse, has never done anything. He's has had no respect for human life or the law, and so we really request that you deny him parole and give us a 5-year set would be awesome. Would be nice to get a break because it is difficult, as you know, we've discussed even driving up here. Once you get that letter in the mail, that's where your mind goes for the past 3 months. We just keep reliving everything in our head and thinking of what we want to say when we need to present to you and what we want to put into our letters to make people understand that, yeah, it happened and it happened a long time ago. And to people, unfortunately, I didn't even get to meet, but the impact that it continues to have on our family as we move forward. So it's very important to our family, and we would really request that you deny him and give us an extended set. Would be very much appreciated.
Thank you for your appearance and testimony. I do have one question for you, please.
Sure.
I've read your letter several times thoroughly, and
I hope you didn't have any typos.
not at all. In your letter, you'd requested a 3-year set. Today, you're requesting a 5-year set. I would just like to.
That was
get
my
some-
typo then. I would prefer a 5-year set.
Okay. Okay.
I think maybe because I probably did say I'm very appreciative of the board, and I don't think it was you guys last time, but we got the 3-year set last time, and I am always very appreciative. We've gotten one time 5 years, sometimes we get 1 year, so whenever we get a 3 to 5 year, it is a relief to our family.
Understood, and thank you again for your appearance.
Thank you.
My name is Georgia Prendergast. My mother-in-law, Mary, in 1971 was tied up and beaten and choked by Freddie Martin. He was caught because a neighbor saw a strange man going into her house, and the police were called, and they caught him. And what he ended up taking from my mother-in-law was her change purse with $8 in it and a child's phonograph. He was sentenced, he served 4 years, he was paroled, and within, I guess it was 3 months of his parole, he'd murdered 4 people. A Mr. Strombeck, he was suspected in that murder. He was stabbed and he was set on fire. Mr. Mullins was stabbed, and then Joanne and Randy's grandparents were stabbed. Judge Sullivan at the trial, when he read the sentence, he said he hoped that in the future parole boards, you would be able to read the transcript of the trial so that you would understand what a predator that Freddie Martin is. Elderly people, people who can't fight back, people who are trusting. My mother-in-law was all those. She did survive. But when my sister-in-law got into the house, all the knives from the kitchen drawer were spread out on the kitchen table. So I think he had some other plans for my mother-in-law. I worry that when you look at Freddie Martin today, you see an old man, and you don't realize that this was once a young man who could inflict terrible pain on individuals and families like ours. My oldest daughter will be 50. She's never known a time without Freddie Martin. This happened 54 years ago to our family. We are asking that he remain in jail. I think it's safer for society that he's there. And I know our family would be appreciative to know that, that our loved ones are still remembered and he's still held accountable. Time passes, but it just happens. It doesn't heal anything. Our loved ones are still gone. We miss them more and more. So thank you for your time, and please consider keeping him in prison. Thank you.
Thank you for your appearance and your testimony. I don't think there's any other protest. I don't know if you want to ask about behalf.
Just briefly, in the original statement of facts, it indicated he was implicated in 6 murders, but he was only convicted of 1. Is that correct?
Correct.
Give me 1 moment, please. I believe that's correct. He was just suspected in the other two.
Okay. But he was only convicted of one, but they suspected he did 5 other murders.
I'm so sorry. Can you repeat that?
Okay. That's all I wanted to verify.
Oh,
Thank
I'm
you.
so sorry. Yes.
I'm sorry, I just wanted to clarify, was he arrested or charged in connection with any of the others?
Give me one moment, please.
I didn't have any information in my file that he'd been arrested or charged in any of the other incidents.
But you mentioned separate sentences for the Alfred couple,
Correct.
so
He was
it's
convicted
2
of
murders.
the murder of Mr. and of Mrs. and sentenced individually for both, as well as for the
All right, so it's
burglary.
2 murders, not 1.
Correct.
Yes, yeah, he had several arrests, but I believe he was only convicted of the attack on Mary Prendergast and then the Al Frank family.
Thank you.
I think in the protest letter, it indicated that at Mr. Martin's jury trial for the murder, the state people presented evidence that on November 12th, he murdered another person. That's in your protest letter. It's the last paragraph. So they presented it, but did not charge him with that.
Yeah.
Any other questions? Seeing none, do you have a motion at this time, Mr.
Motion for closed session for protest testimony.
Okay. Motion for closed session. Second. Motion's been made and seconded. Those in favor respond by voting aye. Aye.
I am, sir. Come on. 1 second. After spending several hours with Mr. Freddie Martin, it was clear that he continues to take no responsibility for the murders of Mr. and Mrs. Alfrank. He also did not express any remorse whatsoever. He would only indicate that there are things about this crime that people don't know, but he would not elaborate. Mr. Martin was willing to and did accept contact information for legal advocacy groups to assist him in his representation. He was also willing to listen to suggestions regarding how he could improve his opportunity for parole release. While, however, he left me with little confidence that he will follow through. I hope I'm wrong. I do want to stress, however, that Mr. Martin was pleasant during our several-hour-long interview. He'll be 78 years of age later this year, and he's been incarcerated for 49 years. Unfortunately, his advanced age and his length of incarceration are the only compelling reasons to consider parole release. However, after thorough consideration, it is my assessment that parole release should be denied, as it would not be in the interest of public safety. I believe there's a substantial risk he would not be able to conform to the reasonable conditions of parole, and that parole release would deprecate the serious nature of the offense and promote a lack of disrespect for the law. My motion is to deny parole.
Motion's been made and seconded by Mr. Heaton to deny parole. Please take the roll.
Mr. Grubbs?
Yes.
Mr. Heaton?
Yes.
Ms. Schaffner?
Yes.
Ms. Taronis?
Yes.
Ms. Tyson?
Yes.
Mr. Boland?
Yes.
Mr. Coates?
Yes.
Ms. Globoker?
Yes.
Mr. Tupi?
Mr. Chair, I
By a
have a
vote
second.
9 to 0. Go ahead.
I'm sorry.
Go ahead.
I have a second motion.
Go ahead and present.
As previously stated, there has and continues to be active opposition from the family members of Mr. and Mrs. Alfrank. And I want them to know that I have read and reread each of their letters multiple times, and I once again thank them for their appearance and testimony today. Your letters are powerful and very impactful. The families requested a 5-year set, and I concur with them. Therefore, it's my motion to authorize a 5-year set for Mr. Freddie Martin.
I'll second.
Motion's been made and seconded by Mr. Boland for a 5-year set. Call the roll.
Yes.
Mr. Heaton? Ms. Schaffner?
Yes.
Ms. Taronis?
Yes.
Ms. Tyson?
Yes.
Mr. Boland?
Yes.
Mr. Coates?
Yes.
Ms. Globoker?
Yes.
Mr. Tupi?
By a vote of 9 to 0, the motion for a 5-year set passes, as well as the motion to deny parole. Congratulations.
I'm just smiling at you.
Franklin Johnson, presented by Mr. Coates.
All right. Thank you. On April 2nd, 2025, I interviewed Mr. Franklin Johnson via WebEx video at Dixon Correctional Center. Mr. Johnson presented by himself, and his interview began at 9 a.m. and ended at 11:26 a.m. Mr. Johnson was put together with a gray sweatshirt and prepared for the interview. Mr. Johnson presented a positive attitude and demeanor for the duration of our interview. He answered all of the questions I presented and was able to communicate his thoughts clearly. To begin our interview, Mr. Johnson shared details into his mental and physical health, information of which I will share with the board in executive session. Mr. Johnson is currently 82 and a half years old and has been incarcerated for just over 47 years. Mr. Johnson was on parole after serving 11 years on a 30 to 60-year sentence for 3 robberies and a rape conviction when he committed the 2 rapes for which he is currently incarcerated. In describing these offenses, I will use the terminology rape instead of criminal sexual assault due to that being the original terminology that was used for Mr. Johnson's offense and conviction. On May 11, 1978, Mr. Johnson was found guilty of rape, deviant sexual assault, burglary, and robbery after a jury trial. He chose to be sentenced under the old law, and he was sentenced to a term of 50 to 100 years on each count to be served concurrently. On August 28, 1979, Mr. Johnson was found guilty after another jury trial of rape and deviant sexual assault. He chose to be sentenced under the old laws, and he was sentenced to 100 to 200 years for the rape and 50 to 100 years for the deviant sexual assault to be served concurrent to each other and consecutively to the sentence he received just a year prior. Mr. Johnson's conviction was affirmed on direct appeal. The appellate court modified the sentence, ordering that it run concurrently with his 1978 conviction. In 1999, Mr. Johnson filed a pro se petition for habeas corpus, which the trial court denied and was affirmed on appeal. In the year 2007, Mr. Johnson filed a pro se petition for post-judgment relief, contending that he had not known the differences between the old and new sentencing laws, and had he known the differences, he would have chosen the new laws. The trial court dismissed the petition and assessed fees and costs for filing a frivolous pleading. On appeal, the appellate court affirmed the decision. In 2015, Mr. Johnson filed an unopposed motion for post-conviction forensic testing, claiming his innocence. During that litigation process, Mr. Johnson stated that he has always maintained his innocence regarding these cases, and then forensic DNA testing was conducted on evidence that was collected in both of his most recent cases. And under the first case, sperm fraction from vaginal slides was examined and matched to Mr. Johnson. In the second case, sperm fraction from a vial of vaginal wash was examined and a partial DNA profile matched Mr. Johnson. This evidence completely contradicted Mr. Johnson's claim of innocence. That was the extent of Mr. Johnson's post-conviction litigation. Mr. Johnson became eligible for parole in November 1987 and has a projected discharge date of November 2076. A brief background: Mr. Johnson shared he is one of 7 children and described his upbringing as rough. His mother worked, and he shared his relationship with his mother's boyfriend for many years was challenging. He was very abusive to his mother pertaining to the boyfriend, which negatively impacted him, as he witnessed that for many years. While his mother was at work, his mother's boyfriend would be home with the kids, and he treated them and his siblings very poorly. They were not allowed to go outside to have fun, and were oftentimes to sit in the center of the living room with nothing to do and were told to keep quiet. This caused Mr. Johnson to begin running away from home on a regular basis in his youth. Statement of facts: on July 6, 1977, Mr. Johnson, at the age of 34, attacked 15-year-old victim Genevieve Jenny Costello as she was babysitting in an apartment at 636 Hinman in Evanston, Illinois. At approximately 1:30 p.m., she and the 3-year-old girl she was watching were outside the building in a wading pool in the alley. After about an hour, they decided to go inside, and as they made their way back to the apartment, the victim almost bumped into Mr. Johnson. The victim and the younger girl went up to the 3rd floor of the building by way of the back exposed stairs. She entered and latched the screen door. The victim put the younger girl in her bedroom and went back into the living room to put on some earrings. When she turned around, she observed Mr. Johnson standing in the doorway with a towel in his hand. Mr. Johnson told the victim to be quiet and began to advance towards her. The victim asked Mr. Johnson to go away and backed away from him. Mr. Johnson ordered the victim into a nearby bedroom and gave her the towel to put over her face. Mr. Johnson asked the victim about the little girl, and the victim told him that she was in her bedroom. When Mr. Johnson went to look for the child, the victim began screaming. Mr. Johnson ran through the living room, back into the bedroom, jumped on the victim, and began choking her with his arm, ordering her to shut up. Mr. Johnson told the victim that he could break her neck. The victim stopped screaming and began to whimper. Mr. Johnson released the victim. She rolled over and the towel fell from the bed. Mr. Johnson told the victim to put the towel around her face and asked her when her husband would arrive. The victim told Mr. Johnson that she was only 15 and was not married. The petitioner then asked when the child's parents would be arriving. The victim told Mr. Johnson that she expected them in 15 or 20 minutes. Mr. Johnson ordered the victim to remove her pants, which she did, and then Mr. Johnson then forced the 15-year-old victim to submit to oral sex upon her, and then forced her to have intercourse. Following that, Mr. Johnson tied the victim's feet up with a scarf and then went to the kitchen and rummaged around for a while, and then left the apartment through the back door. The victim freed herself, locked the back door, called her mother, and then called the police. 8 days later, on July 14, 1977, Mr. Johnson raped another woman, the victim being Noreen Berlin, as she was returning home from a drugstore on her bicycle at approximately 9:30 a.m. She entered the outer door and was unlocking the security door when she saw Mr. Johnson. The victim thought she recognized Mr. Johnson. She said hello and held the door. As she ascended the stairs, the victim glanced back twice and saw that Mr. Johnson was following her. As the victim entered her apartment, Mr. Johnson forced his way in and grabbed her. Mr. Johnson covered the victim's mouth and said, "Just shut up and I won't hurt you." Mr. Johnson asked the victim if anyone else was in the apartment, and the victim falsely answered that her son was there. The victim was able to free herself from Mr. Johnson's grasp and attempted to escape through the back door. However, Mr. Johnson caught her and wrapped a towel around her head. Despite Mr. Johnson's warnings, the victim tried to push the towel up so she could see him. The victim entered the dining room where she screamed and struggled with Mr. Johnson, and then Mr. Johnson threatened the victim with a hammer that he took from the table and told her to stop screaming. Mr. Johnson told the victim that he would not hurt her, but that he was going to rape her. The victim continued to push the towel up, and she was able to see Mr. Johnson's face. Mr. Johnson forced the victim into her son's bedroom, where he told her to undress. At that time, he forced the victim to submit to oral sex upon her for 10 to 15 seconds, and then forced the victim to have sexual intercourse. Afterwards, Mr. Johnson dressed himself, left the bedroom, and returned with a rope and tied up the victim. He then left the residence. The victim freed herself, locked the door, and discovered that the $10 she had gotten that morning was missing from her purse. The victim called the police around 9:50 a.m. and gave them a description of Mr. Johnson. After he was arrested for these offenses, both victims in these incidents positively identified Mr. Johnson in a lineup. Statements as to the offense: when I asked him about the offenses and what he could recall, Mr. Johnson shared most of the things from 1977. He has tried to put them out of his mind. He shared the repressive attitude within him that stemmed from his childhood may have caused him to do some of the things that he did. He felt he was trying to do better as a human being, going to work, taking care of his wife and family, but much of it at times was overwhelming. Many things he was experiencing within his family around 8 or 9 years old caused him to have problems as he got older that he was unaware of at the time. During his education, he learned about himself and how his childhood impacted his choices as a young man. He despises himself for committing the rapes and shared that that is not him anymore. Mr. Johnson shared he didn't really know what he was doing at the time and felt his psychological blocks contributed this to his criminal behavior. He tries not to live in the past and seeks to grow as a person. Mr. Johnson felt it was unhealthy for him to recall the specific details of these offenses and to relive it. He shared these crimes were heinous. When he thinks about it, he doesn't like himself. It was a deplorable thing. For some reason, he states, for some reason, committing those crimes was like relieving a pressure for him mentally at the time. It's very hard for him to picture himself being involved in the rapes. He has a bad feeling when he thinks about those crimes he shared. He shared he is very sorry for what he did, and at the same time, those are the things that he would never attempt to do today. He personally has tried to put the raping, entering apartments, tying women up in the past, as it's just not healthy for him to relive, as he only focuses on growing as a person. He feels he has beat himself up enough over the years for the deplorable acts, and he expressed gratitude to his education and learning about himself and where he was psychologically at the time, where he was at that time psychologically in his life that caused him to commit these crimes. Moving on to criminal history, Mr. Johnson's criminal history is extensive and troubling. In January 1960, Mr. Johnson was convicted of attempted robbery of Mary Smith and was sentenced to 5 years probation, with the first 6 months to be served in the Cook County House of Corrections. In March 1963, Mr. Johnson was found to be in violation of that probation for additional attacks on women and was sentenced to 30 to 60 years in prison. He was convicted of rape and armed robbery, and due to attacking 3 different victims on different occasions within the same apartment complex. He was then paroled in March 1974, and while still on parole for those convictions, Mr. Johnson committed his most recent offenses. Additionally, it should be noted that Mr. Johnson committed the offense of rape with 4 different victims, as he was convicted in 1977 for 2 rapes of the 2 victims. The other 2 charges for the other 2 victims were dismissed due to the sentence he received. Opposition to parole release, Cook County did provide a letter of opposition, and as they are here today, I will have them address their letter of opposition at the appropriate time. I would like to make a motion to go into closed session to discuss some other matters.
Motion been made and seconded by me to go in closed session. Those in favor, respond by voting aye. Aye.
All right, I will continue with the institutional adjustment. I'm starting with his disciplinary tickets. Since 1998, Mr. Johnson has received 11 tickets total, with his earliest ticket since 1998 being in 2005 for unauthorized movement, and his most recent ticket being in April 2024 for unauthorized movement. His tickets range from multiple disobeying of direct orders, insolence, contraband, drugs and drug paraphernalia, and unauthorized movement. In the past 5 years, Mr. Johnson has received 2 tickets, one in 2021 for drugs and drug paraphernalia, and his most recent ticket, I previously mentioned, from 2024. Mr. Johnson was proud to discuss his programming and education and involvement with art. Mr. Johnson taught art classes at Graham for 16 years and enjoyed mentoring other inmates in the area of art and helping them make positive choices, and also helping them understand themselves. He earned his GED and associate's degree in art. He shared he has 3 years of college coursework completed and would like to complete his bachelor's degree. Mr. Johnson is a talented artist and has sold his artwork at art fairs. Mr. Johnson shared being an artist and creating art was healing for him, and he sought to help other inmates use art as a coping skill to the issues they were having. Mr. Johnson prides himself on who he is today and how much he has grown as an individual from his education. Throughout our interview, that was Mr. Johnson's primary focus, as many of his answers to my questions always reverted back to him growing as a man and changing himself, and helping mentor others. Moving on to parole plan, Mr. Johnson would like to parole to the Regeneration Center in Alexandria, Minnesota, which is near his wife, as she lives in Minnesota as well. Mr. Johnson feels he needs support medically, and would be happy with a facility that could support his medical needs. In his statement to the board, Mr. Johnson shared specifically to the victims he is sorry for what he did to them, and that he is sorry that at that time in his life he did not know who he was and was unable to process his trauma from his childhood. He is sorry for all of the difficulties he has caused for you in your life. Mr. Johnson also shared he is no longer the person that committed those crimes. He is grateful for his education, which helped him learn about himself. He focuses now on helping other men with their challenges and would like to write a book to take it a step further in helping men who struggled in similar ways as him when he was younger. He is sorry for the crimes that he committed and would like a chance to live out his remaining days with his wife. His en banc history, Mr. Johnson has appeared before this board, including today, before this board for parole consideration, including today, 26 times since 1986. That is the conclusion of my presentation, and Mr. Tupi, I yield back to you.
Any questions from any board members regarding the presentation of Mr. Coates? Seeing none, we will hear from the State Attorney's Office.
The Cook County State's Attorney's Office does vehemently oppose parole in this case. There's a clear and substantial risk that Mr. Johnson will not conform to the reasonable conditions of parole if he is released. His prior experience with parole and his adjustment in IDOC prior to these rape convictions provide a unique opportunity to evaluate that he is not willing or to conform to parole. Furthermore, to release Mr. Johnson would severely deprecate the seriousness of these vicious, violating crimes against multiple women and would promote disrespect for the law. Mr. Johnson's conduct demonstrated a merciless, sexually motivated disregard for human dignity and human life. And prior to the DNA testing in 2016, he did not take any responsibility for his brutal actions. You heard from one of his victims during the protest hearings. I'd ask that you take that into account, as well as any prior records, videos, and testimony pertaining to the objection to parole. We also request a 5-year extended term for Mr. Johnson. It is very difficult for the victim to have to relive this over and over and over again, and she has, and she's come to parole hearings every time he's up. So accordingly, the people vehemently oppose parole for Mr. Johnson, and thank you.
Any questions for the State's Attorney's Office?
I don't have a question, but I just have suggestion, and I doubt it's something that has escaped you. Ms. Costello has a right to appear and testify anytime that she would like, and we're respectful of that. To the extent that it imposes any psychological or other burden on her to do so, I encourage you to consider creating some kind of a video of her so that she doesn't have to appear and do that, especially in instances where there might be repeated hearings even outside this context, just for what it's worth.
Okay, I think we have the Attorney General's office here. Have you been sworn yet? All right, you need to be sworn.
Do you solemnly swear or affirm that the testimony that you will give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Okay, identify yourself and tell us the Attorney General's position.
I'm Nicole Bartel. I'm an Assistant Attorney General. If Mr. Johnson be paroled, we are requesting a 90-day stay for an evaluation under the Sexually Violent Persons Commitment Act. Thank you.
Any other questions? Mr. Bowling.
It's not a question. I just wanted to make something else, put something else out there for the record. His 12/31/2024 offender overview states that part of his release plans included that he hoped to find employment in counseling, youth, and behavioral modification. And I find that incredibly concerning given the crime, one of which was to somebody known to be 15 before he committed the act. So I think that just needs to be pointed out that even today he's missing that very inappropriate goal.
Thank you. Any other questions? Seeing none, do you have a motion at this time?
I do. I do want to commend Mr. Johnson for the rehabilitative journey and engaging in education to better understand himself. Mr. Johnson was able to articulate himself and recognize how his childhood trauma may have impacted his decision-making as a young adult. Given his moderate to minimal disciplinary ticket history in the past 20 years, combined with his presenting medical condition, I do feel Mr. Johnson does have the ability to conform to reasonable conditions of parole, and that his release would not have a substantially adverse effect on institutional discipline. This does bring me to the deprecation factor. Given the strong opposition in the victim testimony, considering the lifelong trauma and the impact to the victims and the repeated nature of these offenses, I do believe release at this time would still deprecate the seriousness of the offense. So therefore, my motion is to deny parole.
I'll second the motion.
Motion's been made and seconded by Ms. Softner. Those in favor of the motion, please take the roll.
Mr. Coates?
Yes.
Ms. Globoker?
Yes.
Mr. Grimes?
Yes.
Mr. Heaton?
Yes.
Ms. Schaffner?
Yes.
Ms. Tarones?
Yes.
Ms. Tyson?
Yes.
Mr. Boland?
Yes.
Mr. Tupi?
Yes. By a vote of 9-0, the motion passes to deny parole. Do you have another motion at this time?
I do. I will make a motion for a set. I want to share briefly my reasoning behind the motion I'm going to make. So Mr. Johnson is 82 years old, and considering that, his age as well as his health, I motion for a 3-year set.
I'll second the motion.
Motions have been made for a 3-year set, seconded by Ms. Softner. Those in favor of the motion, please take the roll.
Mr. Coates?
Yes.
Ms. Globoker?
Yes.
Mr. Grimes?
Yes.
Mr. Heaton?
Yes.
Ms. Schaffner?
Yes.
Ms. Tarones?
Yes.
Mr. Boland?
Yes.
Ms. Tyson?
Yes.
Mr. Tupi?
Yes. By a vote of 9-0, the motion passes.
Melvin Thugpen, presented by Mr. Tupi.
This is the case of Melvin Thigpen. Mr. Thigpen was convicted of aggravated kidnapping, sentenced to 50 to 150 years, rape 50 to 150 years, and attempt murder 50 to 150 years. He was sentenced on September 27, 1976. The facts of the case were that on December 1st, 1975, the victim was a 17-year-old female who had just finished attending school cheerleading practice and was walking home when the petitioner, when Mr. Thigpen approached her. He then started to ask questions of her, and she kept ignoring him until he put a gun in her back and took her to his car, where he forced her inside and then drove her to a rural area where he raped her at gunpoint. Afterwards, he asked her age. She told him she was 15. He said, "You're just a baby." And he said he was going to take her home, but he drove further out into the country, forced her into a ditch. While he was lying in the ditch, he pointed a pistol at her and fired 4 times. The first shot struck her on the right side just below her ribs and went out her back. The victim cried out. He fired again. The second bullet grazed her left side of her body. He fired a 3rd time and missed, and at this point she ended up falling to the ground and pretended to be dead. He walked away but fired a 4th shot at the victim, striking the ground 2 feet away from her while she was lying there. After Mr. Thigpen left, she went to a farmhouse where she was taken to St. James Hospital in Manny, Illinois. She later identified the petitioner. He went through jury trial and was found guilty of the subsequent charges. My hearing with Mr. Thigpen was scheduled for April 22nd of this year. He's at Joliet Mental Health Center, but he refused to appear at that hearing. In prior hearings, he's refused a number of times. He refused in 2010, 2013, 2014, 2015, 2017. In 2019, he also refused. In 21, he refused. He only had one hearing in 23 with Mr. Heaton, where he appeared, and again, in my hearing scheduled for this year, he did not appear. I am going to go into executive session, so I'd make a motion to talk about some of his mental health issues. Seconded by Mr. Grubbs. Those in favor respond by voting aye. Aye. Do you want to register your objection?
Yes, just briefly. Cook County State's Attorney's Office does strongly oppose parole in this case. It's our position that parole would deprecate the seriousness of this offense and promote disrespect for the law. Mr. Thigpen committed an aggravated kidnapping, attempted murder, and rape of a 17-year-old girl, who he then abducted from a high school, and after abducting her, he brutally shot her and left her for dead. Based on Mr. Thigpen's history prior to his convictions, there's a substantial risk that he will not conform to the reasonable conditions of parole or aftercare release. And finally, I'd also like to reference that he has a significant ticket history while he's been incarcerated. And we also ask that the board considers all prior letters, videos, testimony protesting parole, as well as the new letter that the victim submitted for this session. Thank you.
Thank you. Attorney General's Office.
Thank you. My name is Nicole Bartel with the Attorney General's Office. If Mr. Thigpen be paroled, the Attorney General's Office is requesting a 90-day stay for an evaluation under the Sexually Violent Persons Commitment Act.
Thank you. Mr. Thigpen hasn't had a visitor and has no parole plans. He's not even made any attempt to get any parole plans. As I stated, he has never had a visitor inside the Department of Corrections. He did have somebody try to see him in 2010, but he refused that visit. I will point out that back in 1984, he did have the mayor of East Chicago Heights, who wrote a letter on his behalf and had a petition advocating, signed by a lot of people, asking that he be released. So apparently at one point he did have some ability to communicate with people, but he's currently inside the Department of Corrections, staying in his room and refusing to participate in any type of programming. If there was, this kind of leads me to believe that if we had some mental health institution I could recommend that he be paroled to that was secure, I would agree to do that, but not having that set up for him at the present time and not having any place where we could send him to safely, my motion is going to be to deny. Motion has been made and seconded by Mr. Grubbs. Please call the roll.
Mr. Tupi?
Yes.
Mr. Boland?
Yes.
Mr. Coates?
Yes.
Ms. Klobuchar?
Yes.
Mr. Grubbs?
Yes.
Mr. Heaton?
Yes.
Ms. Schaffner?
Yes.
Ms. Taronis?
Yes.
Ms. Tyson?
Yes.
By a vote to 9-0 to deny, the motion passes. I'm not inclined to grant a motion at this time for any type of set because there's no victim family members here, so we're not putting anybody at further risk. And like I said, I would like to see something done in his behalf to get him some type of some type of inpatient treatment after he was released from corrections.
I'd motion for a set.
Do you? All right, make your motion.
I'll motion for a 3-year set.
I'll second.
Second.
We have a second. Mr. Boland seconds. Please call the roll.
Can I just make one comment before people vote? Remember that we are going to go see a facility. It looks like it's going to be done in July, right around the time we have the clemency hearings, where we're going to look to see if this nursing home we were told about last month is secure and might be a viable place for someone like this. So I don't know what their psychiatric capability is there, but I think the point of Mr. Tupi's remarks are that we're going to be getting more information. If we're not burdening anyone, maybe we should be careful about declining this person to have the option. So,
For what it's worth, I will note that my second is rooted heavily in his continued refusal to even talk to us. And for that reason, I think I'm respecting his wishes to be left alone, and that moves heavily any consideration for parole. So that's where my second is.
Okay, call the roll.
Mr. Grubbs,
Yes.
Mr. Heaton,
No.
Ms. Schaffner,
No.
Ms. Torones,
Yes.
Ms. Tyson,
No.
Mr. Boland,
Yes.
Mr. Coates,
No.
Ms. Goloker,
Yes.
Mr. Tupy,
No. By a motion, vote of 4 to 5, the motion for a 3-year set fails. Okay. Do I have a motion to adjourn?
I'll motion.
We have a motion by Mr. Boland and seconded by Ms. Tyson to adjourn. Those in favor respond by voting aye. Aye. All right, we're adjourned.